stream. Barry, how many push-ups can you do? Oh, never mind. I'll ask you later. We're now streaming live. Ladies and gentlemen, welcome to the continuing public hearing of the House Environment and Transportation Committee. I am, as always, your friendly chairman, Kumar Barve. I'm joined by our vice chair, also friendly, Dana Stein, who is somewhere here, and more members of our committee. So this is the bill order for today. We're going to start with House Bill 861, offered by Delegate Julie Polakovich-Carr. Then we'll go to House Bill 528, which is the St. Mary's Bill, 541, a Montgomery County Delegation Bill, 567, also a Montgomery County Delegation Bill, 574, Montgomery County Delegations, 784, Delegate Terraza. What? I'm just reading out the bills. 784, Delegate Terraza, 785, Delegate Terraza, 824, Delegate Healy, 826, Delegate Healy, and the final bill, 10th bill of the afternoon, is House Bill 877, Delegate Valentino Smith. And so with that, and all sponsors have 4 minutes. You'll see it on the timer. We'll run through it 2 minutes, 2 times. So it's kind of like Love Connection. It's 2 and 2. So House Bill 861, Delegate Polakovich-Carr.
Thank you, Mr. Chair. So good afternoon. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 861, which would authorize the use of reusable tenant screening reports for use by landlords. The bill seeks to improve the accuracy of the tenant screening process and to decrease costs for tenants. By way of background, if it's been a decade or more since you last rented an apartment, the process would likely be unrecognizable to you today. It used to be that you filled out a paper application and answered a few questions before your application was evaluated by a person. Now, 9 out of 10 landlords rely on automatically generated tenant screening reports to evaluate potential tenants. These reports are prepared by an external screening company that uses computer algorithms to run automated background checks. Within seconds, the algorithm generates a tenant screening report, which is sometimes known as a consumer report, that recommends approval or rejection of the applicant. Many of these reports are not reviewed by a human before they are provided to the landlord and can include inaccurate information. Errors on consumer reports are shockingly common. The Federal Trade Commission found that 1 in 4 consumers have a, quote, potentially material error in their consumer report that makes them look riskier than they actually are. And inaccuracies on consumer reports are especially detrimental for people of color. Since the majority of Black and Latino residents rent their homes, they are vulnerable to being rejected for housing applications because of inaccurate consumer information. And this is especially likely to happen if an applicant has a common name, such as the more than 12 million Latinos nationwide who share just 26 surnames. Given the current eviction crisis, many Marylanders will be seeking to rent new housing and may face an even harder time securing housing because of inaccuracies on their consumer report. Ideally, applicants would be able to review their screening report for errors before it is provided to the landlord. But with a traditional screening report, the applicant doesn't get to see the report until after they've been rejected for the apartment. And although a consumer reporting company is required under federal law to make corrections identified by the consumer, the company has up to 30 days to do so. By then, most landlords will have found another tenant. A reusable tenant screening report solves this problem. The report is ordered directly by the tenant, who has the opportunity to review it for errors before the screening company provides a copy of the report directly to the landlord. These reusable tenant screening reports are otherwise exactly the same as a traditional screening report and contain the same kinds of information, including employment verification, eviction housing history, and a comprehensive search of the applicant's criminal history. An additional benefit of reusable tenant screening reports is saving tenants. A tenant can direct the screening company to provide the report to an unlimited number of landlords within a 30-day period. So instead of paying an application fee for every apartment they apply for, they pay the screening fee once. This legislation does not require landlords to accept a reusable tenant screening report. It would be an opt-in system. All landlords, however, would have to publicly state whether or not they would accept such a report. The bill is modeled on a law in Washington state that has been in effect since 2016. There are hundreds of landlords and apartment complexes in Washington that have opted to accept reusable tenant screening reports, including several companies that also operate rental properties in Maryland. As I'm optimistic that if this bill goes into effect, there would be landlords in our state that would accept reusable tenant screening reports. Finally, I'll note that we have written testimony in support of the bill from the Consumer Protection Division of the Office of the Attorney General, the Maryland Consumer Rights Coalition, Renters United Maryland, and Montgomery County Renters Alliance. Additionally, I am working with several stakeholders who will be testifying orally today to work out some amendments to the bill, and hope that we'll have those resolved in the near future, and we'll be sharing those with the committee at that point. So thank you for your time and consideration.
Yeah, it's also interesting that you have as favorable with amendment Lori Graff on behalf of the Maryland Building Industry Association, which is a little unusual for this kind of bill. Okay, so I'm going to go through all the people who are signed up as favorable, and then we will entertain questions for the sponsor and all of the people who are signed up favorable, and they're in the following order: Eric Dunn, Matthew Lozak, Marceline White, and I think that's it for people who are signed up to testify favorable. So let's go to Eric Dunn. Welcome to the Environment and Transportation Committee, Eric.
Good afternoon, Mr. Chairman and members of the committee. Thanks for having me. For most tenants, rental application fees are not a significant expense. I understand Maryland limits them to $25 per adult applicant, and often people will be applying for apartments that cost $1,000 a month or more. But for some tenants, especially those that have eviction records, certain types of criminal history that may have a claim of money owing to a former landlord, it can be very difficult for them to qualify for housing. And so if they have to pay that $25 or $50 fee over and over again, it can really add up. We've seen tenants that have had to pay hundreds of dollars in screening fees. Also social service agencies that may be working with people to leave shelters, to place newly issued housing vouchers in communities that maybe haven't had them in the past, often have to expend their resources to help people find housing and pay application fees over and over and over again. But apart from just the money that's expended with the repeated application fees, another effect that application fees tend to have is that it can really deter people with those types of admission barriers from even applying for housing in the higher quality properties and in the more desirable areas, and really steering themselves into properties and communities where they think they're more likely to be accepted because the landlord can't be as choosy with who they're going to rent to. And so that can really drive patterns of residential segregation, sort of cyclical, concentrated poverty. So rent application fees can be a serious problem for some people. There are different solutions to that. A couple of states, Massachusetts and Vermont, have banned them entirely. The United Kingdom has actually done the same thing. Portable screening reports are another alternative that can enable a person to pay one time for a report they can take around and apply for multiple properties, usually within a limited period of time, and has the added benefit of enabling any errors to be corrected once and the report that's used to be accurate. So this is a bill that takes a step in the right direction by enabling tenants that do have one of these available to know where they can use it. Thank you.
Thank you very much. And yes, I neglected to mention that all witnesses have 2 minutes. So next, Matt Lozak, and after him, Marceline White. Matt, are you in the house somewhere? Well, we'll go to Marceline, and hopefully Matt will turn up after you get done, Marceline. Ms. White, welcome to the committee. I think you have to unmute yourself. Marceline, you have to unmute yourself. There we go.
Okay,
I can hear you now.
Thank you, Chair, members of the committee. For the record, Marceline White, Executive Director of the Maryland Consumer Rights Coalition, MCRC. And MCRC is a statewide organization that advances economic rights and financial inclusion through research, education, advocacy, and direct service. We're here in strong support of House Bill 861 and thank the delegate for bringing it. As you all know, and this committee has been working so hard to address the needs of renters and homeowners this session. As you know, we're facing a health and wealth crisis in Maryland. Before COVID, the United Way report found that 39% of families were struggling economically to make ends meet. And of course, since the pandemic has begun, we've seen thousands of Marylanders lose their jobs, have their hours slashed, or lose their small businesses altogether. At the same time, Many have contracted COVID and are struggling both with medical bills and the longer term effects of lost jobs or lost time and hours. This is a common sense solution to low-income families and those who are struggling, so they don't have to pay the $25 again and again and again, which does add up. And we do work with advocates in Washington State who have said this has been a very effective solution. Again, it is an opt-in solution, so we think this provides a new opportunity for people to save money when you are looking for new housing, which is a crisis and an issue in Maryland, and should not cause problems for property owners as well. So for all of these reasons, we support the bill and urge a favorable report. Thank you.
Thank you very much. Is Matt Lozak in the house somewhere? Matt?
I am here,
Okay.
Mr. Chair. Thank you very much.
Okay, welcome.
Are we testifying, I guess, on 861?
That's right.
All right. Good afternoon, Chairman Barbe, Vice Chairman Stein, committee members. My name is Matt Losak. I'm the co-founder and executive director of the Montgomery County Renters Alliance, an alliance of more than 30 labor, community, religious, political, and civic action organizations, and of course, thousands of renters. We are Maryland's first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. For many renters, especially low-income renters, especially renters of color, it can be especially difficult to find an apartment in Maryland. For many renters, it may be necessary to apply for homes in multiple apartment communities in order to find an available home. But this means having to pay multiple background fees that may make the process too expensive for many and potentially adding to racial segregation in housing. Creating a system where landlords can simply access a credit report, a single credit report, accurate credit report, from a reputable credit screening company using the landlord's own password or code would ensure one-stop shopping accuracy of tenant screening reports and eliminate multiple tenant fees. Further, it would allow for all renters to review their own report information to ensure its accuracy. This bill provides a simple, modern improvement to the rental apartment application process, and we strongly urge the committee's report. Thank you, and sorry for the technical glitch.
No, that's okay. All right, questions for the sponsor or any of the favorable witnesses? Any questions, people? Okay, it looks like, okay, the first question goes to Delegate Boyce, then Holmes, then Jacobs, then Jalisi. So Delegate Boyce.
Thank you so much, Mr. Chairman. I think Matt Losak answered my question. I was reading this bill last night. I didn't 100% understand it. And I think to the bill sponsor, Delegate Polak-Carr, because I haven't rented a house in, I don't know, well over a decade because I own my house. But this is essentially a renter's credit report per se. So someone can just pull it and I just don't have to do the multiple. I just want to make sure I understood that.
Yeah, is that, Julie, is that basically correct?
That's right. So it's just, information that a landlord would use to decide whether or not this is a tenant that they want to rent to based on their income, past evictions, if any, past criminal convictions, if any, et cetera.
And it sits on some type of a renter's database, a renter's creditors type of database where people can just pull from it.
So the data comes from a variety of different companies. Each screening company or consumer reporting company pulls their data from different sources, but I mean, ultimately a lot of that comes from public records and other places. But they're basically, the company is assembling that data and matching it to that particular tenant and generating the report for them. And
so just one very quick follow-up, Mr. Chairman, if you don't mind. So just like credit reports, the more people are pulling from it, sometimes the more you get dinged. Would this work in the same way or not? In other words, some people just know that they want to live in this place. I think to the point of a couple of the folks testifying is that, if you've got a file for 5 different apartment buildings and hoping you get one versus knowing maybe your income bracket, knowing that you can definitely get this one, is there kind of like a ding depending on the amount of apartments you then apply for and the system then using it?
Yeah, my understanding that's not the case. And I'll say I actually went through the process of signing up with one of these reusable tenant screening companies to see what, both as a landlord, which I'm not, and as a tenant, to see what the process looked like. And I noticed, I also pulled my credit report around that same time just to kind of compare what is on both of these products. And I'll note that on my actual credit report, it noted it as a soft inquiry because it was initiated by the actual consumer. So it doesn't actually go against your credit score. At least that's
Thank you so much.
Yeah, that was a big issue when I was on Economic Matters of not having it count against you if lots of people look at your credit. I don't know what happened to that law, but anyway, Delegate Holmes.
Thank you, Mr. Chair. And we continue to hear about these third-party companies that make these decisions for landlords and property managers. And I'm in the business. I don't know of any property managers or landlords that has someone else other than themselves making the decisions. So, and I understand that the property reports, et cetera, are an important part of this. So the question is, if, and I do know that some people are concerned that there may be some false reports. So if it's found out that there's a false report, okay, that was given to the property manager or the landlord, then what is in your legislation to remedy the situation if something is found out to be false?
Thank you for the question, Delegate. And do you mind clarifying, by something false, do you mean inaccurate information that was an error by the consumer reporting agency, or if a tenant tried to,
Oh, that's a very good question. If for example, the applicant's credit score is 460 and the applicant was able to get this rescreening report and to manipulate that through Adobe some kind of way to change that 460 to an 860, and then submitted that to the property manager or the tenant, property manager or the landlord, then what recourse does a landlord have or the property manager have? And particularly property manager, because if I'm the property manager and I base the tenant's application approval on this, and then my client, the landlord, says, "You screwed up, Marvin," then I'm on the hook, so to speak. So what recourse would I have if it is found out later that the tenant manipulated the credit report?
Thank you so much for clarifying your question. So I'll say, first of all, with the companies that I'm aware of that do these reusable tenant screening reports, the company themselves is generating the report. And although the tenant has a chance to log into a portal and to see the report, they can actually edit the report. The reporting agency themselves is directly passing off electronically a copy of that report to the landlord. So for one of these companies' cases, as I just mentioned, I actually went through the process. Both the tenant and the landlord has their own access to that company's platform. The landlord would just log in and see the report directly provided by the consumer.
Oh, I see. I see. So, and sorry, I didn't mean to cut you off, but I think I see it now. The tenant puts an application into a screening company, so to speak. The screening company generates the report, and that report is held into a portal so that any property manager or landlord that wants to see this tenant's information goes to that same portal, which is held by this particular company. Is that what you're suggesting?
That's exactly right.
I think I've got it now. Thank you very much.
Okay, next, Delegate Jay Jacobs, then Jalisi.
Thank you, Mr. Chairman. My question was really pretty much the same as Delegate Holmes, so I'm not going to be redundant on that one. But I see that Maryland Realtors has written only. So, Delegate, have you read the unfavorable letter from Maryland Realtors?
I have seen it. I'm looking at it again now.
Okay.
For a question in regards to
That
that.
part, my question was really pretty much in line with Delegate Holmes about the false reporting. And I think you answered most of that, but unfortunately, Bill Costelli's not going to be testifying orally, so I can't question him, but I was just wondering what your response would be to that letter that they put in, which is partially has to do with the false reports, which you gave a pretty good answer on that, but also about the property managers being able to report directly from the reporting agency.
Yeah, so I mean, again, my understanding is that the report isn't being passed off by the tenant, so the potential there for fraud, I think, is pretty low. And I will note that one of the people who is signed up actually to testify in opposition, we have been talking with that organization to try to work out some amendments that there might be another pathway forward that also addresses some of these concerns around potential fraud, but would give more flexibility to both the tenants and to landlords. So I think you'll be hearing about that shortly.
Okay, thank you.
Okay, Delegate Jalisi.
Thank you, Mr. Chair. So just for my clarification, this is going to be a database which is going to be kept by the state of Maryland? Or are we, so who's going to be the custodian, if you will, of this system?
Thank you for the question, Delegate. Yeah, so the state isn't actually involved at all. These are private companies that do these screenings right now. There's at least one company that operates nationwide and is the major provider of reusable tenant screening reports out in Washington state. And they are a privately held company. The state doesn't have any role in terms of seeing that data or holding on to that data.
So my company uses a company exactly like you're mentioning here in Maryland. It's called TransUnion. It's a subsidiary of TransUnion called SmartMove, and it provides exactly the same information that you're saying. It works in the same way that you're mentioning. Both the tenant and the landlord can log in. They can decide who pays for it, but it provides you with credit reporting, criminal history reporting, national sex offender database search, and the eviction report. So, so help me understand, what is this, what you're proposing going to be different than what mysmartmove.com or TransUnion, and I'm sure other companies are already offering to me or my company.
Yeah, and that's a good point. There are a number of companies out there already that do tenant screening reports and do a variety of different kinds of consumer reports. It's actually, roughly 2,000 companies in the US, and I think there's 57 that are actually registered to do consumer reports in Maryland. Not all of them do specialize in tenant screening reports. The big difference is basically the business model for the company. So with these reusable tenant screening reports, let me back up a step. With a traditional screening report, even if the applicant has initiated the request of that report, I believe most of the time it includes in fine print that you can only use it for that one transaction. You don't have a right to reuse that report. For a reusable tenant screening report, the company has decided that they are basically giving their customers, in this case, the potential tenants, the ability to continue to authorize the sharing of that report with multiple landlords. So to an unlimited number of landlords within 30 days seems to be the traditional model with this kind of business. Whereas with a regular report, you pay a screening fee, you get the report for that landlord, but then for the next apartment, you have to go through the whole process again, potentially with a different company.
Right. So for my understanding, let's say that I use the same example of TransUnion, mysmartmove.com. So if the tenant has a report which they have generated for me, now somebody else, another landlord is using mysmartmove.com, now this time they don't get paid the second time, but the report generated for my company will be used for the next landlord. That's what you're saying, right?
I suppose that's possible. I'm not actually entirely sure how that would work. Since there are a number of companies that do the screening, if a tenant applies for 3 different apartments, I'm not sure what the odds are that those 3 landlords would be using the same screening company or not.
So my thinking is, which company would say, okay, we generated one report and it's going to be valid for 30 days. And any number of landlords who contact us for the same tenant, we won't charge again and again and again. So do you have a company like that in mind? What's the name of the company you mentioned works in Washington?
That's right, but they operate nationwide. I have confirmed that with them. They do provide screening reports in all 50 states. So that's just one example. I think that there are other businesses, especially as this idea catches on and advances in other states, that will move into this space as well.
So, Mr. Chair, one more question, if you will. So my, just from my understanding, so you're bringing this to Maryland General Assembly. So how is it going to be different than what happens in the marketplace on its own? Like, what is the, like, what are we going to be inputting in terms of making it easy as a process? Are we going to be mandating a company to do it, or how are we going to help is my question.
Yeah, that's a fair question, because right now a tenant could get a reusable screening report, could order that right now in Maryland. It's not clear how many landlords would actually accept it at this point. So the big thing that the bill actually does does require all landlords to say whether or not they will accept one of these reports. So basically, when a tenant is shopping for an apartment and looking through apartment listings, they're going to see that information as part of the apartment listing or on the apartment complex's, promotional website, so that they would know that they can make informed decisions about where they want to apply to or not, and know, will they have to keep paying the application fee or not.
Okay, so the bill basically makes a registry of landlords which are going to accept the reports from this one or two companies and be sharing that information over a period of time. That's basically creating a registry, right?
It's not actually a registry requirement. It just says that for each landlord that they would have to post in a conspicuous manner whether or not they would accept the reusable tenant screening report. And the bill currently as drafted also says that they would have to include that on their website if they have a website.
Okay, I've got two other people.
Okay, thank you. Yeah, thank you, Mr. Chair.
Delegate Healy and Harrison in that order.
Thank you, Mr. Chairman. Thank you, Delegate. This is a very interesting bill. I just wanted to ask about, focus again back on the realtor's testimony. They seem to have two issues. One of them is about that your bill would prevent them from charging a fee of any kind. It doesn't just say an amount of a fee but blocks them. And so how would this get paid for? Would the tenant pay for it one time and then it wouldn't be a cost to the landlords at all?
Right. So with a reusable tenant screening report, the tenant actually orders the report themselves and pays for it themselves.
Okay,
and right now with landlords, sometimes that is the case. Sometimes they say you need to go to this screening company and request the report and you pay, and then it only gets used one time. Sometimes the landlord, charges the application fee and basically uses that to partially recoup their screening costs.
Okay, so it's possible for the landlords to completely be off the hook on under your bill.
Right, they wouldn't have direct costs for screening. Yeah, and I'll note that Mr. Dunn is kind of a national expert on this, and he might have something more to weigh in terms of on the application fee piece.
And the other question had to do with again the question of whether or not the landlord can access this directly from the company and not have to go through the tenant or the prospective tenant to get the information. As this a business practice that's used a lot where people have used this kind of a portal system?
I do believe that there are even outside of reusable tenant screening report companies that this is something that exists. Again, there's probably other witnesses that are signed up here today who have more experience from the industry perspective as to whether or not that's the case. But I think that is
that is the kind of safeguard for the landlord, is that they can use a portal system and they don't have to rely on any other person. But is the company liable for the information that they give? Are they being correct? Can the landlord go after the company for having false or inaccurate information?
That's a great question. I would actually have to defer to one of the other witnesses if they know the answer to that.
Okay, I'll wait and see what they say. Thank you.
Tenant screening reports are a type of consumer report, so they're governed by the Fair Credit Reporting Act, the same as any other type of consumer report would be. And so companies that prepare consumer reports of any kind, including tenant screening reports, are required to follow reasonable procedures to assure the maximum possible accuracy of the information that they're reporting. And the Act provides a cause of action for people who are injured by inaccurate reports that result from unreasonable procedures. There's also a dispute process to get errors corrected and so forth.
Any other questions? I see Delegate Harrison put her hand down, so I assume your question was answered. Okay, thank you very much. We will turn to the opponents of the bill, and they are Chris DePietro and Eric Ellman. I guess we'll go in that order, or Eric, do you want to go first?
Sure, I'll go first, Mr. Chair. Thank you very much. Eric Ellman with the Consumer Data Industry Association, CDIA, a longtime witness at Economic Matters, but I'm happy to be in this committee for the first time. I guess that makes me a longtime listener and first-time caller. So thank you. The Consumer Data Industry Association is a trade association of consumer reporting agencies, which include companies that produce these residential screening reports that we've been talking about. And the sponsor and I had a conversation the other day, and we do have some concerns with the bill. We've testified, we've signed up in opposition, but I feel confident that we can switch our testimony to favorable with amendment. I feel like there's progress that we can have that will be a win for everybody, to protect the landlords who are concerned about fraud, to protect the consumer reporting agencies, which are our members who are concerned about fraud and liability. Some of those fraud and liability questions have already been addressed by some questions today. There are some competition issues that I think we can also address. So I think I have a high degree of confidence that we will get to where we want to go between us and the sponsor to do right and do good by landlords, consumer reporting agencies, and of course the consumer tenants that we're talking about as well. A couple of quick cleanup comments. I guess there was a question about the more you check your report, the more dings you get. That's not true. In fact, that has not been true in the 25 years that I've represented CDIA. It may have been true in the past, but it's a myth that continues to circulate in the marketplace. But that's just not true. In the remaining 13 seconds left, Mr. Chair, I don't have anything else to add, but I'm happy to answer any questions that any members of the committee have.
Oh, very good. I knew I liked you for some reason, Eric. Chris, go ahead.
Sure. Mr. Chairman, members of the committee, Chris DePietro, also here on behalf of CDIA, the Consumer Data Industry Association. Eric Ellman told you about our conversation that we had with the delegate on Monday. I think we kind of fell victim to the requirement that we had to sign up 2 days prior to the hearing, which meant we had to sign up on Friday. As the bill was introduced, we were opposed to the bill, but as Eric said, we had a very good and productive conversation with Delegate Polakovich-Carr, and I think we will come to a meeting of the minds, because I think our issues that we raised can be fixed. As the delegate stated, this type of legislation was passed in Washington State. To my knowledge, there's no other state that has passed a similar bill. I think what we want to do here in Maryland is get it right, because we do think that other states will look to Maryland as a model on this issue, and that's what we're working towards. So we will continue to do that, and once we do have amendments ready for the committee, hopefully in very short order, we'll get them to the sponsor and to the committee council and to subcommittee chair in that order. So thank you very much. Happy to answer any questions.
Any questions for the recently opposed, but more recently favorable with amendment, possibly?
Exactly.
Yes, Delegate Boyce. Delegate Boyce?
Thank you, Mr. Chairman. I just want to clarify. I mean, I've heard the discussion about fraudulent reports on behalf of the renter, but I question the opposite. We've heard bills recently about discrimination, for instance, against individuals with records who want to rent properties. And so I'd be curious about the opposite in this case, how the renter is also protected through this measure. I mean, Eric, I heard you mention that as well. I didn't hear you mention the protections of the renter.
Yeah, good and very important question, Delegate Boyce. Thank you for that. Since for a half a century, since 1970, the Fair Credit Reporting Act is a law that governs and protects renters and residential screening. And Maryland, of course, has its own state version of that federal law, which has also been in place for a number of decades. And it has a fairly robust set of notice, access, choice, a right to correct, a right to redress if in fact a consumer still feels aggrieved. So there are fairly robust protections where consumers can access their consumer reports or their credit reports, often multiple times a year, often for free. We are required by federal and state law to resolve disputes in a timely fashion. Most credit reporting disputes are resolved in 10 days or less. And even though the law sets a maximum period of time of 30 days. So there is a fairly robust and active dispute resolution process and a fairly heavy set of consumer protections for consumers and a pretty heavy set of legal obligations on consumer reporting agencies and on anyone that uses data from a consumer reporting agency or furnishes data to a consumer reporting agency.
Thank you.
Okay, any further questions? Seeing none, thank you very much. That ends the hearing on House Bill 861. We'll proceed to a local bill, House Bill 528. And Mr. Vice Chair, you have the con.
Thank you, Mr. Chairman. And
You ready, Dana?
yes.
Yes.
Delegate
Okay,
Clark.
Delegate Clark, representing Calvert and St. Mary's County. I have a local bill here, House Bill 528 for St. Mary's County. And what they're requesting is the repeal of their impact fee and authorization of a building excise fee. Couple reasons for that is when you have an impact fee, it gives you less flexibility than an excise tax fee. An impact fee, the money has to be used in a general area of where it's collected. With an excise tax fee, it can be used throughout the county for any lawful purpose. It's a one-time fee. Impact fee currently is collected at the time of construction permit. An excise tax can be moved out over a period of like 3 years on your tax bill. So it's less of an impact on folks when they're building a new home or in a commercial development when they're building a new development. Basically, they want to repeal the impact fee and then go straight to having the authority for the building excise fee. You can see from the comments that all the comments are favorable. We have a letter from a delegation, a letter from the county commissioners, a letter from the finance department, and also a letter from the Maryland Building Industry Association. I want to make this short, so it's a local bill, and we would look favorable to having this passed.
Okay, thank you very much, Delegate. Let's see, we do have a question from Delegate Healy.
Yeah, thank you, Delegate. I just want to clarify, is this being done anywhere else in the state of Maryland at the local level?
Oh, it's been done in a lot of counties. Matter of fact, we did it in Calvert County back, I'm dating myself a little bit, but probably I think around 2002, 2003. It just gives you more flexibility as to where you can spend the money. You can take the money from a high-end development and use that impact fee
to improve schools and roads and things like that
Sure.
in another section of the county.
Yeah, I'm
And
just
that's-
verifying that it's not creating a new precedent, a new way of taxing it at the local level. That's all.
No, ma'am. In fact, I think if you look at in some of the supporting documents, there may be a list of the other counties that have it and how
That's
they
fine.
use it. Okay.
Thank you very much.
And I got the letter from the delegation. I didn't forget about that.
Very good.
Okay.
Okay, next, Delegate Boyce.
Thank you so much, Mr. Chair. Delegate Clark, can you give me an example? When I was reading this last night, the first thing I thought about was money gets stuck, for instance, when you say an inflexibility. Can you give me an example of like the current situation and how maybe money gets kind of stuck in a place where maybe it could be used somewhere else, so on and so forth?
Yeah. Well, with an impact fee, you're supposed to use the impact fee. Say I built 100 houses and I had all the impact fees. And I think in St. Mary's County, the impact fees around $6,000 or something like that on that 100 houses. It's supposed to be used in the general vicinity of them 100 houses for parks and roads and schools and amenities of that nature. Okay, but suppose that area where them 100 houses are already has fairly new schools and roads and the parks and all that was up to snuff. You're really supposed to keep that impact fee money to be used in that specific area somewhat. If you change it to an excise tax fee, and it's just a kind of a play on words, take an impact fee to excise tax, you could take that excise tax fee and take it into your incorporated town. Say like in St. Mary's County, you could take it down around Pax Naval Air Station and some of the communities down there and improve the parks and roads and some of the school stuff there. So
same purpose, but you could put it somewhere else, for instance.
Yeah, it's the same purpose, but you can move it around your county where you want to use it for any legal use.
But the same type of project. So in the example that you stated, let's say somewhere else needed the school, but you already have the school in that area. You could essentially use the money for the school in the other area.
You could use that for something to do with the school there and the parks and any roads or anything like that. And if you look in their test in the fiscal note, they're predicting that they'll be about even on collection of as an impact fee and excise tax fee.
So the same money is going to be used in impact, but you can spread it out.
Yeah, that gives them more ability to be flexible as to where they use it and how they do it. And also, one thing that an excise tax fee does that an impact fee may not is give them the ability to have that excise tax on some commercial development also. So it could be $1 a square foot or $4 a square foot, whatever. And you notice in the comments that the building association in St. Mary's County agree with what they want to do and are in favor.
Thank you, sir.
Back. Delegate Love, then Delegate Terraza.
Thank you, Mr. Chair. Delegate Clark, have you had a chance to look at NAOP's letter? They sent it just prior to this, to our hearing, and I know we were in another meeting, but NAOP sent a letter with some concerns. Have you had a chance to look over it?
No, I haven't seen NAOP. The only thing I have is the Maryland Building Industry MBIA testimony. Which is a building association. I think that's a state building association too. So no, I haven't seen NAOP yet.
Okay. Well, when you get a chance, I would appreciate just hearing your thoughts on that. Thank you.
Okay, thank you.
Delegate Terraza.
Thank you, Mr. Chairman. Just following up on Delegate Boyce's question. So if you can take the money from maybe where you don't need it and put it where you do need it, which sounds great. I guess the question is, couldn't it go in the opposite direction? Couldn't money keep being used in the same areas over and over again and not be used? Because the idea of an impact fee is the area that's being impacted. So if there were an area where you were developing more and more and more, which may not be as big an issue in your neck of the woods, but couldn't it be the opposite as well? Like there's less of, I mean, couldn't it be the opposite? I guess is my question.
Well, I guess you could. I guess it could be, but you have to look at it this way in local politics and commissioner forms of government. You run for that position countywide. It's not like you have your own little turfdom just keep putting everything in your one area. County commissioner forms of government tend to be more responsive to the whole county in all areas. And just like any county, I mean, there's some areas of St. Mary's County that's on the water and that have extremely big and expensive homes, and other areas where you have apartments and condos and things like that, where you're not collecting the same amount of or excise tax or impact fee. And right now it's impact fee. If you look in here, if you build a house now in St. Mary's County, up to 1,200 square feet, it's $4,989. If you go from 12 to 2,400, it's $5,383. If it's over 2,400 square feet, it's $5,686. So it's more money, and where the bigger houses and more expensive houses are. So when you go into the areas that need it the most, where you're seeing the smaller houses, you're getting a lesser amount on the impact fee to start with. And the reason that is so that they can have the affordable housing be built in, the smaller units and stuff like that for seniors and families starting out and things like that. So it just gives the flexibility to be able to move it and spread it around quite a little bit.
Thank you. I really appreciate that answer.
No problem.
Delegate Clark, I've got a question. It doesn't directly relate to your bill, but I should know the answer to this. Do county commissioner forms of government, are they typically elected at large or by district, or does it not matter?
Well, most of them are elected by, you take St. Mary's County, there's 4 districts and a president. So you can run for one of 4 districts, and you can run for the presidency of the board, but you run through the whole county. Your votes you get voted for by everybody in the county.
But you have to, so if you have 2 people running against each other from District 1, whoever gets the most votes countywide wins District 1, is that the way it works?
Correct.
Okay.
Correct.
We used to have some.
Yeah, if you take Calvert County, we have 3 districts and 2 what we call at-large seats. So when you file to run first, second, or third.
Okay, so it's a mix. It's basically a mix.
It's a mix.
Okay. Any other questions for the St. Mary's County bill? Any more questions for Delegate Clark? No one signed up in opposition, so that does it for that bill. Thank you very much. We'll proceed now to House Bill 541, Montgomery County delegation. I assume, Delegate Moon, that's why you're here.
He actually recently had to depart. He had a conflicting hearing in judiciary, so I assume he'll be back.
All right. Well, you're going to take it.
I'm not. I do not feel comfortable taking it. I think he'll be back to do it. I'm just voicing of attendance.
Okay. Well, we'll skip over that and we'll go to another Montgomery County delegation bill, House Bill 567. So who's presenting that? Do you suppose it was David also?
I believe is that Delegate Crutchfield? Delegate Crutchfield, you're on mute.
Oh,
sorry about that.
Okay, Charlotte. Okay, yes.
Yes, it's me.
Okay.
Good afternoon, Chair Barve and Vice Chair Stein and all the members of the Environmental and Transportation Committee. So for the record, I'm Delegate Charlotte Crutchfield, representing District 19 in Montgomery County. And thank you for giving me the opportunity to come before you and testify today in support of House Bill 567. So House Bill 567 will ensure that the governing bodies for common ownership communities in Montgomery County, such as cooperative housing corporations, condominiums, and homeowners associations, conduct reserve studies every 5 years or conduct an update of an already existing reserve study every 5 years. A reserve study is a long-term budget planning tool which identifies the status of the reserve fund by conducting a study for future major repairs and replacements of the common elements of a cooperative, condominium, or HOA. The reserve fund consists of money set aside for scheduled routine and unscheduled expenses for maintenance, repair, and replacement that otherwise will be drawn from a general fund. This bill provides the guidelines and standards for the manner in which the reserve study should be conducted and prepared, and it provides for the governing body review of the study, inspection and copying of the study by homeowners, requirements for submission with the annual proposed budget to homeowners, and budget guidelines for reserve funding and allocation of funds towards the proposed funded amount. With this legislation, Montgomery County homeowners living in these common ownership communities will continue with the quiet enjoyment of home ownership without the risk of mandated, costly, and sometimes excessive assessments for scheduled, routine, and unscheduled expenses associated with their maintenance, repair, and replacement. I respectfully request a favorable report for House Bill 567, and thank you again for your support on this.
Okay, so we have nobody signed up in opposition. Oh no, there is one person who's in opposition, but it's only written opposition. But let's go to the proponents: Stacy Gelfound, David Gardner, Jeremiah Pope, and Mark Fine. So we'll start with Stacy. Stacy, welcome to the Environment and Transportation Committee.
Thank you, Chairman. I appreciate the time today to talk to you about the support that we have for this reserve bill. I have been in community management, managing condominiums, co-ops, and homeowners associations in Montgomery County since 1989. And one thing that we have seen is that when associations do not have reserve studies or do not update those reserve studies, they tend to fall behind in funding their reserves. And I have multiple associations over the years that have ended up having to do special assessments, or just recently we had 3 condominiums in Germantown that needed to do a 30 to 40% increase in condo fees during this pandemic time, and because of the fact that they were not, they didn't have the reserves properly funded. And so there's deferred maintenance going on, and items like roof replacements and pipe replacements aren't being able to be done. So I believe that by having this bill, it would allow owners of the association to know what it is that's supposed to be refunded, and put the board of directors on notice and make them available that they have to fund these reserves and in order to do these long-term projects, so that we're not looking to have individual owners being special assessed or have major large increases in their assessments year to year. Thank you.
Thank you very much. Next, David Gardner. Mr. Gardner? Okay, we'll go on to Jeremiah Pope. That's actually a staffer for Delegate Crutchfield, I guess. So,
do you have me now? Do you hear me now?
Oh yes, David Gardner, go ahead.
Sorry.
You got 2 minutes. Welcome.
All right, I'm appearing on in support of House Bill 567. I currently serve as the chairman of the Legislative Committee of the Commission on Common Ownership Communities for Montgomery County. I know Mark Fine is our chairman, and he'll be testifying shortly. For years, our committee has supported a bill requiring that common ownership communities conduct a reserve study on a periodic basis, and that they fund the monies that are necessary to fully implement the reserve study. This year's bill is modeled after one that was passed last year for Prince George's County that requires a reserve study to be done and updated every 5 years, and that the association fund the replacement reserves in an amount equal to at least that recommended by the reserve study. I've been a practicing attorney in Montgomery County, and I've represented common ownership communities for over 20 years. In my own experience, I've had a community that had to close its pool because they didn't have the monies to make the replacements to that pool, which caused all of the children in that community to have nowhere to go in the summer. I've seen, as Stacy has, many communities that go out, either have special assessments or go out and borrow money from banks in the millions of dollars to fund replacements when they don't have the money in their reserve fund. All this will do is require that they create a reserve fund, that fund be funded with the amount necessary to do the reserve, so people living in the community are paying their fair share as they go along, rather than have a special assessment imposed, 10 years later on some new resident that buys into a community with a place that needs a roof replacement. So I think this is a good bill, and I highly recommend it. Thank you.
Thank you. I presume Jeremiah Pope is just, Mr. Pope, do you want to testify?
No, he should just, it's just, I think the testimony itself, the money that was submitted.
Okay, Mark Fine then. Mark?
Yes, sir. Can you hear me?
I can hear and see you.
Okay, thank you. Good afternoon, Mr. Chairman and members of the delegation. My name is Mark Fine. I'm the chairman of the Montgomery County Commission on Common Ownership Communities. I too, as with Stacy and David, are here to support HB 567. Your home is your biggest investment. In Maryland, there are 6,700 community associations representing over 515,000 homes. Montgomery County, the CCOC oversees 1,100 common ownership communities, roughly 142,000 houses, or 36% of the homes in Montgomery County. A lot of the boards are reluctant to raise assessments even to cover a yearly increase in expenses. Many even borrow from the reserve to cover their operational expenses. Many do not make contributions to the reserve fund on a regular basis. Reserve studies are critical to help the board avoid financial emergencies within the association. When a large expense happens, the association, if they've planned accordingly, they can avoid it. Instead, they have to utilize reserve funds to cover those expenses. Unfortunately, upfront expenses translate to fewer costs in the future. Without the reserve study and proper planning, it may mean either scrapping projects, calling for a special assessment. Unexpected fees can be destructive to the communities. They create problems with association members and difficult to get these assessments passed. The numbers are clear. After switching to annual reserve studies, increases in assessments have gone down by 31%. In closing, I ask that the committee protect the 6,700 common ownership communities representing in Maryland and pass the study. Thank you.
Thank you very much. We'll entertain questions. Before I recognize the two people who have their hands up right now, Delegate Crutchfield, we have a statewide reserve study bill that's been introduced by Delegate Holmes.
Yes.
Do we need this local bill?
Yes, I think we still do need this local bill. And I will I see Delegate Holmes who's kind of waiting there. I'll let him also, I'll defer this to him really.
Yes, I was using my mental processes to predict what, okay. I think I don't know what order you put your hands up in, but I'm going to call on Delegate Holmes first.
Thank you, Mr. Chair. And Delegate Crutchfield, in her answers about needing two bills, the reason why there are two bills this year, much like there were two bills last year, is because the statewide bill did not get through last year. And because the statewide bill did not get through last year, Montgomery County was tremendously disappointed, Mr. Chair, which is why you see the statewide and the Montgomery County bill in now. Now, the other portion of that is if the statewide bill passes, then neither the Prince George's County bill, which was passed last year, nor the Montgomery County bill would be independent of the statewide bill, okay? But
so Marvin, would it be safe to say then that at a minimum, passing the Montgomery County bill is at least an insurance policy in case the statewide bill fails again?
And that's exactly what's here, Mr. Chair.
I just always know what you're going to say.
And I do have one question I want to put out
go for
anyone,
it.
To anyone, and it's basically is kind of a refresher from this morning. Can anyone? The question is, do you think this is for anyone? Do you think a reserve study is necessary for all common ownership communities, no matter what the size? Some argue that if they're small, they don't need it. This question is for anyone who wants to answer it.
I think Mark Fine will probably be the best person to answer that. Would you do that for us, Mark?
Absolutely. Delegate Holmes, you're not going to like it, but my answer is yes.
That's good.
We are seeing a lot more problems with the smaller communities.
That's right.
Of the 1,100 communities in Montgomery County that are common ownership, 46% of those communities have less than 50 homes. And we're seeing a great deal of those associations struggling right now.
And that's the exact answer I was looking for, Mr. Fine. You hit the nail right on the head. Thank you, Mr. Chair.
Okay, I guess I'm going to stop this love fest right here and now and say that we've concluded the public hearing on House Bill 567. One group did write in opposition, the CIA, Legislative Action Committee. So please feel free to read that at your leisure. We will go now to, hold on, let me just see if, yeah, okay. House Bill 541, is Delegate Moon around? No. Okay, we'll go to House Bill 574. Who's presenting that one? It's a Montgomery County.
It's me, Mr.
Okay.
Chair.
Go ahead, Janelle. You're up next. 4 minutes.
Thank you so much. Greetings, Mr. Chair. Hello, Mr. Vice Chair, members of the committee. Great to see everyone. I am Delegate Janelle Wilkins, presenting HB 574 on behalf of the Montgomery County delegation. This is a bill that we brought before you, I believe, about 2 times. And once again, we have the overwhelming majority of the delegation in support of this bill, and also the county executive. Montgomery County is strongly behind this legislation. This bill is about keeping people in their homes and affirming the right to housing. And we've really seen, every single one of us, how important having a stable home is. And outside of this pandemic, the consequences of being evicted are just as strong. This bill deals with evictions at the end of a lease, which is known as tenant holding over. And it requires a landlord to provide a reason listed in the bill when they decide not to renew a lease. The basis for this is that whenever someone is displaced, whenever a landlord decides that they no longer want someone living in their home or renting their home, we need to ensure that there's a high bar anytime a family or individual is at risk of losing their home. We've seen end of lease retaliation, and we want to ensure that all of our renters are provided a reason and that we have a high standard and that people are not displaced. Lastly, this legislation is the law in over 14 jurisdictions across our country, and the doomsday scenarios that our landlords provide around this just do not end up occurring. So I ask the committee to authorize the Montgomery County delegation to move forward with this legislation, and I urge a favorable report.
Okay, thank you very much. First, the following people are going to be testifying, and everybody gets 2 minutes, even elected officials. No, I'm not picking on you. That's session began. They are Kate Stewart, well, Janelle Wilkins already testified. Chris Perry, Zephyr Shah are testifying in favor, and I believe that's it. So let's go to Kate Stewart, Mayor of Tacoma Park.
Great. Thank you so much. I'm glad to be here today. The City of Tacoma Park supports and urges favorable consideration of HB 574. This bill promotes stable housing by requiring a landlord to state a justifiable reason before evicting and displacing residents. The bill articulates the many reasonable circumstances that would qualify as reasonable cause. At the same time, the bill provides protections for renters against potential unfair treatment, discrimination, or surprises that could have far-reaching adverse impacts, not only on individuals and families, but entire communities. In the midst of the global pandemic, this legislation is even more important. Even during the eviction moratorium, tenants have only been protected in failure to pay rent cases. Landlords and property owners have never been prohibited from filing tenant holding over cases, which is what the Stable Homes Act addresses. These cases can be brought when a landlord does not want to renew a lease. This can happen when there are legitimate reasons, like those causes listed in the proposed legislation, or if the property is being taken out of the rental market. Under the current law, however, a landlord does not need just cause or any cause at all. Through no fault of their own, families can be displaced. City staff and myself personally have witnessed the devastation of involuntary displacement, a lifetime of belongings quickly packed up or left on the street, ruined by rain or snow, older residents or young families quickly scrambling to find a place to stay, and children moved from one school to another. All of this negatively impacts not just these individuals and families, but our whole community. Therefore, the City of Tacoma Park urges your support and favorable vote on HB 574, and we thank Delegate Wilkins for her work on this issue. Thank you.
Thank you. Next, Chris Perry.
Good afternoon, Chairman Barbie. Can you hear me okay?
Yep, I can hear and see you.
Good afternoon. Also, Vice Chairman Stein and committee members. My name is James Christopher Perry, and today I speak as Vice Chair of the Board of Directors of the Montgomery County Renters Alliance in support of the Montgomery County Stable Homes Act. I'm a retired Air Force veteran, and my wife and I have lived on a fixed income in an apartment in downtown Silver Spring for over a decade. Every year, our landlord sends us a formal invitation to extend our lease for another year or two. If we don't receive the invitation, we must leave our apartment at the end of the lease term. The landlord need give us no reason. He simply terminates the lease. Let's be honest about why we need a Stable Homes Act. It's about protecting some of your constituents from retaliation for insisting a landlord provide maintenance and services guaranteed by law or lease. Often standing up for your rights risks being evicted in the middle of a national pandemic. Although there are anti-retaliation laws on the books, it's nearly impossible to prove a landlord has retaliated against a tenant. I'm sure there are members of this committee who, as landlords, make sure all your tenants live in a safe, comfortable dwelling. But some landlords skimp on building materials, hire unqualified repairmen, and generally regard a complaining tenant as an annoyance rather than as a resident demanding services for which they've already paid. For those who insist that a term lease is just that, we question your motive for destabilizing a family who just wants to continue to lease their apartment home. Stable quality housing is not just an over-the-counter commodity. It is an essential human need. And wouldn't voters be well advised to elect delegates who aspire to protect the essential human needs of their constituents? I ask you, please protect thousands of Maryland renters by voting favorably and quickly to support the Stable Homes Act to require a good reason or just cause for prohibiting us from continuing to live in our homes. Thank you.
Thank you. Next, Zephyr Shah. Zephyr, welcome back to the committee.
Thank you, Chairman Barve, Vice Chair Stein, and members of the committee. My name is Zephyr Shah, attorney in the Human Right to Housing project at the Public Justice Center, and we've supported iterations of this bill for several years and continue to urge a favorable report so that Montgomery County renters have stable housing for good reasons. Public Justice Center has seen time and again during the COVID-19 pandemic that tenants are vulnerable to arbitrary lease terminations that frankly exploit a loophole in protections, just as Madam Mayor described. We're amid a once in 100 years pandemic, and unfortunately, lease termination and consequent displacement expose Marylanders to transmission of the coronavirus. And this is not hypothetical. In my written testimony, I've shown data from the judiciary of Maryland, limited data that we have showing increases year over year for tenant holding over cases in which the only allegation that a landlord has to prove is that they provided an adequate amount of notice. No reason for notice of termination required. We're seeing, for instance, in just Montgomery County, almost a 100% increase in November of 2020 compared to November of 2019 in tenant holding over actions. This trend of tenant holding over actions filed in lieu of failure to pay rent actions just makes sense if you're a landlord. They have no burden of proof in these cases other than to show that they provided the adequate notice. In Montgomery County, that's 60 days notice to quit. I want to make a note about retaliation. Retaliatory defenses in Maryland law require the burden of proof on the tenant. This bill changes the burden for the landlord to show that they had a just cause as enumerated in the bill. That's a powerful change of law, not just as to notice, but as to due process in court. Thank you for your time. We urge a favorable report.
Okay, thank you. I see, hold on. Delegate Boyce.
Thank you so much, Mr. Chairman. I know this bill has come in many iterations, and I every year I have the same question because I am often worried about what our role is as it relates into a contract. And just cause, meaning if my lease is up, I have a year lease, 5-year lease, whatever, and my lease is up. I just want to be sure that this bill is saying if my lease is up and the landlord says that they're not renewing my lease 60 days before the end of my lease, that is not just cause that the lease is up.
Delegate Boyce, what the bill is saying in terms of our role as legislators, it's to ensure public safety, in my opinion, to make sure that there's a bar and a standard to ensure that retaliation or other nefarious factors are not taking place. So what the bill is saying is, yes, the lease is still up if the landlord chooses that they do not want to renew that lease, but it's saying provide a reason so that we can have a sense and make sure that we are balancing the public interest. That's what it's saying. So for example, when we had the delegation hearing, he didn't come to testify today. I didn't want to overload you all today. But when we had the delegation hearing, there was a gentleman, a senior citizen, who was testifying in the middle of the pandemic from his motel room because his lease was up, and we understand that leases end. And prior to that, though, he had requested a repair in his building. And he had been a good tenant, no issues, again, senior citizen, all of that. And the landlord decided in the middle of the pandemic not to renew his lease. So he was calling into our hearing from his motel. I think that in terms of this bill and balancing the public interest and making sure that when landlords make these decisions, that it's not retaliation, it's not discrimination, it's not something else taking place, that the landlord can simply say, not renewing your lease because of XYZ. It creates a standard. It creates a way for us, in my opinion, in terms of the public interest, to balance the public interest. There are lots of stories that we hear from tenants who also don't want to speak up because there's that power that the landlords have to not provide any sort of reason. If I speak up in my apartment building and my landlord decides, well, you got to go. So that is, I totally understand where you're coming from. At the same time, I think that we do have the authority, and we've used it historically, to step in the public interest and say, provide us with a reason. You don't have to keep the person there. Provide us with a reason.
So just a quick to follow. So you're saying, at least in Montgomery County, cases where the gentleman, the constituent you talked about, where they terminate the lease in most cases, it's been retaliatory and not necessarily a reason that the lease is up and they decide we're not renewing this lease for whatever reason. Or maybe it's because they know they need to fix it and nobody knows. I don't know. I don't know why. But I'm just saying, so that's that's the basis of this, is that folks who request adequate housing are not getting it, and therefore someone is using the fact that the lease is up to then get rid of them.
Those are the anecdotal stories that we have heard time and time again. However, because we don't have just cause and landlords don't have to provide a reason, we don't know what their reasoning is because they don't have to provide one. So what this bill is saying is, Regina, you don't have to keep me in your home, but give me the reason on what I have done, or let me know that you are no longer putting the house on market, or whatever it is. Provide that notice and that reason. That's what we are trying to get to. But because landlords don't have to provide a reason, we don't know, all of the range of reasons.
Got it. Thank you, ma'am.
Any other questions? Seeing none, thank you very much. We'll go to the opponents of the bill, and they are Bob Enton and Aaron Bradley. So we'll start with Bob and then go to Aaron.
Thank you, Mr. Chairman. I for some reason, the camera's not working, so you don't get to see me today. I want you to know I am dressed appropriately. Thank you. Robert Enton on behalf of the Maryland Multi-Housing Association, and I think on behalf of the owners of residential property that are members of our association that rent out hundreds of thousands of homes to Maryland citizens and tens of thousands of homes to Montgomery County citizens. We are very, very strongly opposed to this legislation. Let me make one thing perfectly clear. This bill is not about just providing a reason. This bill says that even though you have a contract with a tenant who has agreed to a term of 2 years, 3 years, 5 years, whatever it is, and that contract ends, when that term ends, that it's not about providing a reason. It's you cannot terminate the tenancy unless one of the reasons is one of the reasons enumerated in the statute. And those reasons that are enumerated in the statute, quite frankly, are unbelievably vague. The tenant substantially this, the landlord substantially that. The bottom line is that this is a contract and either party can walk away from it at the end of the term. You're not going to impose the law both ways and say the tenant can't leave at the end of the term, but what this bill does is imposes it on the landlord. I would also tell you that the number, contrary to what you heard, that as for the reports that we have from the Montgomery County study, which was done several years ago, which was a 150-page study of eviction practices in Montgomery County, the total percentage of foreclosure of evictions that come about as a result of a tenant holding over is numerically less than 0.6%. 0.6%. And in fact, there were only a total of number of evictions in Montgomery County when this study came out. There were 836 evictions. So I'll close, Mr. Chairman. Thank you very much.
Okay. Aaron Bradley.
Good afternoon, Mr. Chairman, committee members. Aaron Bradley, for the record, representing the Apartment and Office Building Association of Metropolitan Washington. Committee members have heard from AOBA on this issue several times in the past, and we've submitted a detailed written statement, so I'll limit my comments today. As we've stated before, there are stringent retaliatory eviction laws on the books, and per the county's Landlord Tenant Commission, retaliatory evictions are infrequent. Further, 98.6% of evictions are for failure to pay rent, as Bob alluded to earlier. And despite the fact that in typical years, only 1% of leases aren't renewed, AOBA members understand that there is a need to do something to ensure that residents aren't left unhoused on short notice. As such, AOBA supported another bill that came before the committee to change notice requirements when they choose to not renew a lease. But it's important to remember that this bill isn't about notice to tenants or even notice to the court about why a resident's lease was not renewed. This bill only allows a housing provider to evict or not renew a lease at the end of its legal term if a housing provider can prove in court one of a limited number of reasons. AOBA doesn't discount the serious ramifications of residence displacement, but each tenancy is unique and comes with unique challenges. We need to maintain the flexibility in how those challenges are addressed by allowing housing providers, professional staff to determine when a lease needs to expire. So I'm here for questions and thank you.
Okay, we have two questions. Let me see in which order they are. Vaughn Stewart gets the first question, then Delegate Jalisi. Vaughn.
Thanks, Mr. Chairman. I'll be brief. I know that this is deja vu all over again for all of us. Mr. Enton, thank you for being here. Obviously, we've chatted about this bill previously. I just want to illuminate a point, though, for my committee members who are not from Montgomery County. You mentioned how a very small percentage of overall evictions are tenant holding over evictions. But I just want to be clear that in the vast majority of cases, isn't it true that when tenants get notice that their lease won't be renewed, they just leave and therefore do not go to court, correct?
I don't know if I have any factual data to support that. The only thing I do have factual data on is that the number of tenant holding evictions on account of tenant holding over is ridiculously small. There was no mention of that in a 150-page report done by the Montgomery County Rental Property Commission, whatsoever. I would say this to you, that a landlord who decides, in Montgomery County, according to the study, it takes anywhere from 10 to 20 weeks to go through an eviction case. The last thing any landlord wants to do is not renew a lease for a tenant. In addition, they estimate that it costs somewhere between $6,000 and $16,000 to renovate a unit and get it ready for re-rental. So if I have a landlord, if you look at the bill, one of the just causes are a tenant has caused a substantial breach of the lease, okay? This tenant has engaged in disorderly conduct. How am I going to go to court and prove that the tenant engaged in disorderly conduct? What is the definition of a substantial breach? This bill is just not workable.
Well, Bob, I tip my hat to you. You're a pro at turning my yes or no question into some extra. I tip my cap. But just to be clear, isn't it true that it's entirely possible, in fact, extremely likely, that by only looking at numbers from the court cases that actually go to trial, we are undercounting and not paying attention to the far more common scenario that people get the notice that their lease hasn't been renewed and that therefore they leave without ever stepping foot in court?
So I won't make a speech this time. I'll answer your question. One of the things that I find so interesting about this bill is when you go to the end of the bill, it calls for all kinds of reporting of data. And to have a draconian bill like this on speculation about, how many there are, how many there aren't, what are the reasons? If you had a bill that said we want to study the basis upon which landlords do not wish to renew a lease, fine. But I don't know the answer to your question. I don't think you know the answer to your question. And the county's rental agency doesn't know the answer. So if you want to study it and get the facts that would then show that this legislation is necessary, we'd be all for that.
Thank you, Bob. Appreciate it.
Thank you, Delegate.
Delegate Jalisi.
Thank you, Mr. Chair. So my question was just, from my understanding, this is a Montgomery County only bill. If it is passed, it's going to impact only Montgomery County. And the county executive of Montgomery County is supporting it. So why is this not going into the Montgomery County Council, which I would assume is a better place for something like this to be passed and implemented?
Well, I guess I think my sense is having, as an attorney and someone that's been doing this for a while, is that even though it's, that's why.
No. This question is not for you. It's for the sponsor.
Oh,
well,
why are they not taking it?
Hold on. We're only doing questions of the opponents, but I think
okay.
I can answer your question, and the answer is county governments don't have the ability to just invalidate contractual relationships in such an easy manner. If they did, the Montgomery County Council would have done this by now. But I think this legally requires an action of the state government. I suspect is the reason, but I can find out if I'm correct or not on that.
Because I see a lot of laws, tenant landlord laws in Baltimore City, which are much different than Baltimore County and other counties. So I'm sure that the county councils have more flexibility than.
You know what? We would have to ask council to find out the answer.
Okay.
But otherwise, it's
Okay. Thank you, Mr. Chair.
Yeah. Okay. There appear to be no further questions. That concludes the public hearing on House Bill 574. I believe. Yeah. That concludes it. Let's go to House Bill 541. Is Delegate Moon with us yet? No Moon. Okay, so we will then go to House Bill 784. Delegate Terraza, I know we've got you here.
I am here. Thank you, Mr. Chairman. Good afternoon, Mr. Chairman, Vice Chair Stein, esteemed members of the Environment and Transportation Committee. Thank you for this opportunity to present House Bill 784, which is identical to the amended version of legislation Delegate Lehman and I introduced last year. That bill, House Bill 1316, passed the House as amended, but did not make it over to the Senate because of COVID. That legislation was modeled off of legislation the Howard County Council passed in 2018, which required builders to make new homes EV ready. So what does House Bill 784 do? It applies to builders of new single-family homes that have either a garage, carport, or driveway, and it says that they must provide buyers and prospective buyers with the option to include either a level 2 charging station or a dedicated line running to the garage, carport, or driveway with sufficient voltage to at least put in a level 2 charging station. And they also have to provide notice about that and specific information about any rebate programs. This basically recognizes that it is significantly more costly to install. It's more cost effective to install these when you're building a house rather than to come in after construction. And it is based on the idea that making this process easier and cheaper will encourage people to switch to zero emission electric vehicles, which should in turn help us meet our goal of reducing greenhouse gas emissions. And just a quick note, I wanted to let you know, I spoke with BGE, the Director of Government and External Affairs, and they are in favor of this bill. They just didn't get a chance to submit testimony, but we'll be sending a letter, which you should receive later this week. Also, there's an amendment I put in at the request of Tesla. Is that my first 2 minutes? I forgot to look at the clock.
Yeah, you've got 2 more minutes.
Oh, I won't take that. I'm just letting you know that I have an amendment that I put in the request of Tesla. They said the definition in the bill of the level 2 charging station was too narrow for them. And they wanted a slightly, basically it includes, the reference includes a specific connector geometry, which is different than what they use. And they said Tesla users could use an adapter, but they wanted this amendment to ensure that all level 2 charging products would meet the definition. And also if there were wireless charging stations or other things in the future, that would work out.
Okay.
Verbal report.
Okay. I mean, it's funny thing. Everybody seems to, your bill really has to do with the wiring, correct?
Yes.
Yeah, it doesn't require people to install a charger or do anything like that, just to have the wiring.
It doesn't require anything. It doesn't require the installation of anything, just the option.
The option to wire.
But they could either wire or put the charging in itself.
Okay, but I mean, the reason I say this is that even most electric cars, all you need is the 240-volt plug that you plug your washer dryer into. You don't need to go and buy the $500 thing. So I don't want to require people to buy that. Okay, a number of people have signed up in favor. Paul Berchinsky, Tom Clark, Lori Graff. I think that's it for oral testimony. So Paul, are you out there?
Yes, I am. Can you hear me?
I can, and you have 2 minutes. Welcome back to the committee. I believe we've seen you before, haven't we?
Yes, you have.
Okay.
Good afternoon, Chairman Barve and committee members. I'm Paul Verchinsky, and I represent the public on the Zero Emissions Electric Vehicle Infrastructure Council. HB 784 would take a modest step forward to future-proof new residential single-family and townhouse development by having developers' representatives offer the option of chargers or pre-wiring. Why is this important? There are several reasons. This helps build out the EV charging infrastructure. This provides convenience for EV drivers to charge at home. And this can future-proof housing in Maryland. Maryland's greenhouse gas reduction plan is predicated on reaching 300,000 electric vehicles by 2025. Modern electric vehicles now have enough range for most applications. So the next obstacle to electric vehicle adoption is a lack of charging infrastructure. HB 784 will allow drivers a place to charge where they park overnight at their residences. Please report out HB 784 favorably. Thank you.
Thank you very much. Next, we will go to Tom Clark. Tom?
Yes, good afternoon, Mr. Chairman, members of the committee. My name is Tom Clark. First of all, a tip of the cap to all legislators for your COVID Relief Act. Thank you for working together. We appreciate that. House Bill 784, it's a good bill. A lot of it's legislation for environmental purposes or regulating stuff, they're closing stuff. But 784 gets right to the point. It's about utilization. It gets young people involved. We can do whatever we want. We can close this. We can make all kinds of laws and lead. But until we get John Q, Have it a Grace, or Mr. and Mrs. Crofton involved, it's a mute point. So this is getting them involved, gives them the option. And I think young people do it. I think in a couple of years, you'll see this as a standard item. The builders will include this as standard item. I think it's going to be a hot number. I think people will like it. It's not, like Delegate said, it's not just cost effective. I think it's safer to do it when that house is being built. I know as an electrician, all the time, people say, well, I want this done. Well, we need to pull a permit. It needs to be inspected. Nah, no one does it. Okay, after the house is built. I think this is the safest way to go. Anytime you avoid extension cords and all that, and it gets done right, I think it's good for everyone. And I think it's a good bill, and I think it gets the Marylander involved. And I appreciate your time. Thank you.
Thank you very much. And then finally, we have Lori Graff on behalf of the Maryland Building Industry Association, favorable with amendments. Lori, you out there?
Yes, hello, Mr. Chair, members of the committee. Thank you for taking the time to hear my testimony on House Bill 784. I'm Lori Graff. I'm the CEO of the Maryland Building Industry Association. We represent 1,200 companies around the state of Maryland with residential construction. We do support this legislation. It is a step forward. We've always had the attitude that this really needs to be market driven. This gives buyers options. So we support that absolutely. Our one concern had to do with projects that are already in the ground and have already started. So we did reach out to BG&E on the delegate already, and I also want to thank the sponsor for reaching out to us. We've had a couple of conversations about this and we'll continue to do so. But I did reach out to BG&E to find out what problems this could cause for communities that are already in the ground or already in the planning phases. And they did say that they had some concerns about if it's in the building stage or in the planning and design, there could be delays and other things because they're going to have to redesign around this specification. So we are asking for some type of grandfathering for projects that have already started and have already started the building phase or the design phase of the project. I will anecdotally tell you, we do have one of our very large builders that just started doing this within the last month. So I reached out to them also, and they did work with the utility companies because there is some design issues with this and making sure you have the capacity and the load. And they indicated that it was going well. They had worked with BG&E and Pepco and others to make sure they could do this. They did end up starting it with just the communities that have the natural gas because those will have certainly have the capacity and there won't be any capacity issues. But they look forward to doing it in the future with all of their communities. But it is a planning issue for some of these communities that have already started building. So other than that, we support this legislation and look forward to working with the sponsor on it. So thank you.
Okay, we have a couple of questions, and I think the first question goes to Delegate Harrison.
Hi, good afternoon. And actually, my question was around the same issue that was just brought up. Let's say you have a community that's being developed in phases, and one or more phases has already been started, building permits have already been pulled, and then, but you have another phase or one or more phases that may be coming later. How does this affect them? I mean, it's already gone through all of its approval processes, and it's just really a matter of doing the actual construction. You know, how will that affect them? Will they have to go back and go back and look at? I don't know how much it would cost to do this or offer this. I'm assuming it wouldn't be too much more, but it's a different, I guess, level of technology or electrical technology that will be in the house. And so, is it going to affect their financing? They've, a developer may have already gone through all of their financing. So, you know what I'm asking? How might this affect them?
Delegate Harrison, thank you for the question. I appreciate that. And I know that MBIA has expressed some concern about this, and I'm happy to continue working with them. But what I would say is that this is, and maybe Mr. Clark can weigh in on this, but what this essentially is a 240 outlet. So this is like what you put in for your dryer. This is like another dryer outlet in your house. I think Chairman Barve was also mentioning that as well. And so it's not something that can't be added later. If the concern with, and I did speak with BGE, and I think there's some confusion. I don't think they're concerned about this bill. And I think they're going to clarify that. But if there's, so people add these things to their homes all the time. I don't know if there's a concern that if you add a lot of them after construction, that might there might be a tipping point in there. I don't know. I'm happy to work more with MBIA on that, but otherwise I don't quite understand that because people add things all the time.
Okay, I was really just concerned about phased construction and with approvals that have already occurred. And if it's just, a regular outlet like a dryer, then it doesn't seem like it should be a big issue.
I think Paul may have had an answer for your question. You put your hand up to answer it, or?
Yes. To give you an example, I put a charger into my garage. My amperage on my service panel was 100. I had to double it to 200 for a variety of different reasons. That cost me $1,000 to do right off the bat. With the newer houses, there's a standard basically of around 200 amps. This is just a question of having enough amperage at homes. And I believe in most cases, you will find that adding a charger can be easily accommodated. The issue may be if folks want a larger amperage service for faster charging, which can happen because you can go to a 60 amp service. So that's kind of my answer on this. In most cases, it's not going to affect the builder in the next phases.
By the way, just for information's sake for the committee, no one is signed up in opposition to this bill the way it's written. Delegate Lehman. You know what? You're muted.
Thank you. Just really quickly, thank you, Mr. Chair. Delegate Teresa, thank you for bringing this bill back. Quick question about the rebate language. How do consumers right now learn about those rebates? I remember the BGE representative last year saying that they were looking for ways to get the word out. So I'm glad that language is in the bill. But otherwise, how do people, maybe any of the other EV car owners might know, but how do people know about these rebate programs?
That is a good question, and I'm going to defer to EV owners on that.
I'll bet if we ask the building industry, I bet the building industry, when they're selling houses, they tell prospective customers that there are rebates for all sorts of things, solar and stuff like that. Even if they're not building it, I'm sure they tell people that. Paul, do you have the answer to that?
Yeah, right now, BGE and others are providing inserts in bills that provide the information on rebates and their link to EV Smart on their website. So that information is pretty much available to everybody. Thank you.
Okay.
Thank you.
Mary, you good? Okay, so that concludes the public hearing on House Bill 784. Once again, in vain. No, we'll go to Delegate Terrazas' next bill. We'll go to 785. I'm not going to ask about David Moon yet.
Okay, well, I hope you enjoyed the break from landlord-tenant, because we're back to landlord-tenant issues now. So good afternoon, Chairman Barve, Vice Chair Stein, and esteemed members of the Environment and Transportation Committee. Thank you for this opportunity to present House Bill 785, which would require a landlord to give a tenant notice that their rent is late and then wait 10 days before filing an eviction case. Unlike most states, under current law, Maryland law, eviction begins with a landlord filing a failure to pay rent case, and the tenant is then served with a summons to appear in court. For many tenants, that summons is a first notice that the landlord has not received the payment in full on time. Whereas in most states, before the case is filed, the tenant receives notice, which gives tenants the opportunity to seek rental assistance, work out a payment plan, or find other housing before they end up in court. While there are multiple opportunities along the way in Maryland to cure this through the right to redeem, I think it's up to 3 times a year, generally, and 4 times a year in Baltimore City, and avoid actual removal from their home, there are still many problems with this process, including the impact this can have on the tenant's credit scores, employment, and future housing, not to mention having a major impact on mental and sometimes physical health of the tenant and their family. This process also places a tremendous burden on our judicial system. Maryland is an outlier among surrounding states in that surrounding states have eviction filing rates ranging from 3 to 18%, whereas Maryland consistently has an 80% eviction filing rate. According to Attorney General Brian Frosch, every year, approximately 660,000 failure to pay rent cases are filed. In some counties, the filing rate is as much or more than 100%, which means that as many eviction cases are filed every year as there are rental units in those counties. In fact, in Baltimore City, there are 125,000 rental units and 140,000 eviction cases filed. And however, only about 6,500 of those actually result in eviction. That means in the courts in Baltimore City, for example, there's potentially burdened with 133,500 cases that may not have needed court action. In Howard County, 24,000 cases are filed and only 500 lead to eviction. The good news is that many of the cases, both in the city and throughout the state, are settled and people are not removed from their home. But by getting the courts involved so early in the process, the courts are essentially forced to serve as collection agencies for landlords. This places undue burden on the courts and the local sheriff departments, forces them to take valuable resources away from more pressing issues. I'm not saying that all of these would be resolved without filing court, but would be settled could be settled more simply and less expensively for the whole system. So
You know,
basically,
somebody needs to mute themselves because I'm hearing some noise in the background. Go ahead.
So basically what the bill says is that prior to filing an eviction case, landlords will be required to let the tenant know and give the tenant notice that the rent is unpaid. And when notice is received, the landlord must wait 10 days. A quick note about COVID also is that once the pandemic ends, I know that a lot of the moratoriums and other things have been extended, but this would be critical for that. Renters would be notified, get notified of where they stand and given a few extra days to get a handle on their circumstances, and if needed, seek help address unpaid rent issues, housing assistance, and seek alternative housing. There are a couple amendments. One of them is that a number of people have expressed concern about the first-class mail return receipt requested, and so that will be changing. We're going to work on that, and there's also an amendment that just gives more detail about what the notice should include. And I urge a favorable report, and happy to tell you more about that if you have questions.
Okay, well, let's go to Zafar Shah, Grayson Wiggins. No, Zafar Shah is testifying in favor, and then we'll entertain questions. Zafar, I see you there. Go ahead.
And thank you again, Chairman Barve and members of the committee. Zafar Shah, attorney at the Human Right to Housing Project at the Public Justice Center. I'm also testifying today on behalf of Renters United Maryland, a coalition of over 30 organizations to which Public Justice Center belongs. We urge a favorable report on this bill. One is hard pressed to think of another industry other than the multi-housing industry that uses a summons in a lawsuit to serve as notice of a payment dispute. And that's exactly what Maryland law currently allows landlords to do month after month in the district courts throughout the state. House Bill 785 disrupts this industry practice and promotes in its place engagement between landlord and tenant to resolve non-payment without burdening the courts and creating extensive case history on tenants' rental and credit checks. In my practice, it is rare that small landlords immediately file eviction cases without prior communication with their tenant. But in contrast, it is the professionalized large holdings housing providers that prefer to skip engagement with their tenants about late payment and simply churn eviction cases through the courts. We've seen this in discovery and document production and litigation against some large landlords in Maryland, and see just how automated this practice is. Companies export spreadsheets literally on the 6th day of the month, send that data to a bulk filing vendor, and then have that vendor file just hundreds of fair to pay rent cases at a time, typically before or by the 10th of the month. And HB 785 is a simple but crucial fix to this kind of overuse of the courts. Pre-filing notice or notice and cure period is not a new concept. More than 40 other states and DC require pre-filing notice. DC is an important analog to our situation because they have not only a right to redemption like we do, but a 30-day pre-filing notice and cure period. They only have 0.5 eviction cases filed per cost burden household compared to our 2 eviction filings per cost burden household. Simply put, notice and cure periods are an effective way to reduce litigation and promote out of court pre-litigation resolutions. So we urge a favorable report on this bill. Mr. Chair, I just want to also note that there's a correction to our written testimony to correct a statistical figure of 11 times to 4 times, and I'll send that to committee staff.
Okay.
Thank you.
Okay. Yeah, good. That's good. Okay. So I don't see Delegate Lehman, so I'll have Delegate Healy ask her question.
Thank you, Mr. Chairman. Delegate Terraza, did you see the testimony from the judiciary, the court system? It seems like they should be a beneficiary of this bill, and so have you talked to them yet about working out some of their issues that's raised here?
Yeah, thank you for the question, Delegate Healy. I have not had a chance, but I do plan to communicate with them later today. I know my staff was going to reach out to them earlier, and I don't know since I was in session and then committee, not sure if they've had a chance. But I do understand the concern about the clerk's office having to figure out when the tenant was received the notice. So, but I think that falls into the same issue as the concerns that I heard about the first-class mail return receipt requested. It seems like both proponents of the bill and those who are opposed to the bill had concerns about that. So if you look at perhaps looking at 10 days after the landlord provides the notice with some way to verify when the landlord provides the notice, and maybe that can be filed with it. I think this piece can be worked out pretty simply.
I'd be happy to work with you on that in subcommittee.
Great.
Because I did a bill on notice in the past regarding foreclosures.
Wonderful. I'll take you up on that. I appreciate it. But I think that piece can definitely be worked out. And given that 660,000 cases are filed every year on this, I do think they would be a beneficiary of fewer cases being filed. Thank you.
Thank you.
Delegate Lehman. No? Okay. Zuffer, I have a question for you. I mean, I get that you don't like the fact that the landlords jump to the court, and we may not necessarily disagree on that, but I mean, is it true that the court is the only remedy that landlords have? I mean, for example, if you don't pay your electricity bill, they can just turn off your power. Or in my business, I have customers that are, you know, they're backed up not having paid invoices for 4 months. And I just call them up and say, we're not picking up your hazardous waste next week unless you send us the $500 you owe us. I mean, I have the ability, and other businesses have the ability to avail themselves of self-help, but landlords don't. They have to. The only way they can get a remedy is by going to court, regardless of whether they do it too quickly. Don't you agree, though, that that is the only remedy that they have?
Thank you for the question, Chairman Barve. So fundamentally, yeah, I agree with you. Landlords may be surprised to hear that. There has to be ultimately accountability, and the court system provides that in lieu of self-help, which no one wants to see in our state. But
right,
importantly,
no, we don't want that.
Yeah, this bill is about the timing. It doesn't absolve tenants from late or non-payment. I think in the example of an energy company, certainly good public policy is that they do not immediately shut off power when someone's late. But in this context, the summons, the lobby for the multi-housing industry fondly says the summons is the notice, or the lease is the notice. We're just talking about a 10-day period ahead of filing a court case. Court cases are not for nothing. You know, they are a serious matter. Unfortunately, I think the practice in our state seems to be that it's okay to have 670,000 lawsuits filed, and it simply has so much. It has a tangible harm for the people involved, and whether it's through mediation, a repayment plan, rental assistance, there are a lot of remedies that can be pursued in that 10 days or even longer if a landlord prefers to wait to file their case rather than immediately resorting to litigation. I just want to point out one statistical figure, which is that year after year, we see in the judiciary statistics that between 20 and 30% of these eviction cases are dismissed without any judgment. So we're seeing, you know, for instance, a quarter or 1 in 5 of cases resolve by the time the case gets to court. I think we'll see more cases resolve as you have a 10-day notice and cure period in addition to the time before trial.
Okay, Delegate Boyce.
I just wanted to say, isn't it so that with any other bill you have a grace period? So for instance, with your mortgage, it's due on the 1st, you have 15 days until, you know, anything happens. BG&E is the same way. Your phone bill is the same way. You know, any bill you have a due date and then you have a grace period. Isn't that so?
Is that for, yes, thank you.
Yes, sure, anyone. I mean.
Yes, it is so. And in fact, what all of those will do is send you notice that it's late. And
right. So in other words, it's given that grace period to renters instead of saying
right.
rent is due on the 1st and then we'll charge you
Right.
Essentially sue you on the second day because I haven't received it on the
Right.
6th.
Right. Well,
I end up getting it in 15 days.
Right. Well, some landlords will give a 5-day grace period voluntarily. That is not in the law and is not, and it's not a requirement by any stretch of the imagination. So that if they don't do that, they don't, I mean, that's just out of the goodness of their heart. So, right. So this I think is really important to give that time for a tenant to work stuff out. Thank you.
Delegate Learman. Oh, wait a minute. Did you want to respond to that, or can I go to Delegate Learman? Delegate Learman, go ahead.
Thank you, and thanks for bringing this sensible bill. Could you tell me the how you arrived at 10 days? I'm just curious, and if they're 10 calendar days or 10 business days, just trying to understand where that number comes from and why that number is important versus some other number.
Mr. Shaw, do you have a sense of the 10 days? I know that I know looking at the surrounding jurisdictions that falls in the center of that, but maybe you can talk more about that.
Is that what it is? Okay.
That's right. So around the country, when we look at when I mentioned more than 40 states or jurisdictions, you see a range that's mainly between 3 and 14 days, and certainly the more progressive these states lean towards 7 to 14. In 2016, we had a bill that went to summer study that proposed a 14-day notice and cure period. 10, I think, is really not only within the range of states and DC, but it's a compromise. It's not meant to unduly harm landlords in the process of collection of rent.
Hey, and one of Brooke Learman's questions was, is it calendar days? Is it business days? Does it include holidays? How's the bill written, Delegate Terrazza or Delegate Shaw? Delegate Shaw.
Not yet. It's calendar days under the timing rules in the Maryland civil rules. This would simply be counting all days within the 10-day period.
Well, Mr. and pardon me for interrupting, Brooke, and I'll let you have the floor back, but this leads me, Zuffer, to another question. I had a really painful voting session in my first term as chairman over the argument of something in landlord-tenant over whether it should be calendar days or business days and whether holidays should or shouldn't be. I mean, I have to tell you that it was, I think that was a part of that bill that we summer studied, and to a certain extent, it just became a gigantic headache because people started to, on either side, not just you, but also the landlord side, started to say, well, it ought to be this kind of day versus that kind of day. And, both sides are trying to play it for their policy advantage. But it seems to me that, boy, it would be really great if we could make it consistent throughout the whole code for landlord tenant of it either being calendar days or business days or whatever. That's just a comment. That's really not a question. Brooke, did you have more to say on this?
No, I'm good. My question was answered. Thank you.
Okay, that was a real headache, let me tell you. Okay, unless there are any further questions for the sponsor or the proponents, let me go to the opponents. Grayson Wiggins, Catherine Howard, Wayne Penzick, and then Aaron Bradley and Bill Costelli. So let's start with Grayson and then Catherine Howard on deck.
Good afternoon, Mr. Chairman and members of the committee. For the record, Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. We do respectfully oppose the bill for a few reasons. First was the logistic piece. To clarify, we have not seen the amendments from the sponsor that address the return receipt requested, but we are concerned about that provision within the bill because it may create significant delays in the repossession process far beyond the 10 days contemplated within the bill. Mail is largely delivered during the day when many tenants may be outside of the home. Further, tenants may refuse to sign for receipt, indefinitely delaying the process. I would just note that property owners generally require a 1-month security deposit when the lease is signed. The bill's delivery and notice requirements may further extend the repossession process and place property owners at greater financial risk beyond what is covered by the security deposit. To be clear, tenants already received 2 forms of notice for a repossession hearing. Further, tenants may pay the unpaid rent at any time prior to the actual eviction being enforced and remain in the property. And I would just note that our members are happy when that happens. By law, the notice that is delivered to tenants currently is via first-class mail and posted on the tenants' units. For these reasons, we do believe this 3rd form of notice is excessive, and we would request an unfavorable report. And I would just note, Mr. Chairman, that you have a great point. Landlords cannot shut off services to the tenant. Our only option is to file in court currently. Thank you.
It's funny. I actually threatened not to pick up somebody's waste, and they said, no, the check's on the way. We need this waste to be picked up. So like an idiot, I picked it up, and they didn't pay me. Okay, Catherine Howard, and then Wayne Penzick on deck.
Good afternoon, Mr. Chairman. Hope you can hear me.
I can hear and see you.
Great, that's terrific. I'm very happy to be here. I'm Kathy Howard with Regional Management, Inc. I am also the Legislative Committee Chair, co-chair for the Maryland Multi-Housing Association. I think that Mr. Wiggins did make basically pretty much all of my points with regard to the registered mail component of this bill. If we have had an experience in Baltimore City where there is a local law here that it gives it at one time had a certified mail requirement for tenants to be getting a notice. And unfortunately, about 85% of that certified mail was returned over a 2-year period. And the city and we had to come to an agreement to get rid of that and in favor of a certificate of mailing, which is a proof that the mail has been sent. And that certainly makes a lot of sense. And if I were to put an amendment on this bill, it would be the certificate of mailing requirement, which I can give to your staff, Delegate Terraza. I just want to also clarify, it is industry practice to have a 5-day grace period. It is not codified anywhere at the moment, but that is our industry practice in the multifamily industry before we do anything like file in court. So that 5-day grace period is something that we are relatively used to, and I think that we practice it as a very big standard in the industry. And I just thought that you all should be aware that that is industry practice, and although not codified, it's something we live by.
Okay, thank you very much. Next, Wayne Penzick. Did I pronounce your name correctly?
Very close. Pencheck is the proper pronunciation.
Pencheck, okay.
Well, thank you, Mr. Chairman and members of the committee. As stated, my name is Wayne Pencheck, and I, along with my wife, Debbie, invested in rental properties to help provide for us in our retirement. I'm 71, retired, and receiving Social Security. My wife is 65, working 1 day a week, and is not yet eligible for full Social Security benefits. We own 7 properties, all of which have mortgages on which we currently make monthly payments. 9 tenants reside in our 7 properties. At the current time, 5 of those tenants are delinquent for the total amount of $28,350, plus another $791 of unreimbursed water bills. We are aware of only 1 tenant actually being affected by the pandemic. Bill 785 handcuffs the private landlord in the beginning of the eviction process on delinquent tenants. First, by requiring the landlord to send notification via registered mail. The bill assumes that the delinquent tenant will accept the piece of mail and/or will pick it up at the post office if the notification is left at their residence. Of our 5 delinquent tenants, 1 will not answer the phone nor the door. The remaining 4 tenants make only sporadic contact with our property manager. There is no reason to expect these tenants to accept that mail notification, which therefore extends the time the tenant remains on the premises without making payment. Additionally, the bill assumes that the United States Post Office will deliver the mail in a timely manner. Second, assuming the tenant signs for the registered mail, the bill further hinders the process by requiring the 10-day grace period prior to filing court papers. This extends the time the tenant can remain on the premises without making payment and could cause the delinquency to cross over into yet another month, thereby increasing the total amount due, making it even more difficult for the tenant to rectify the situation and for us to make the mortgage payments. The normal security deposit of 1 month seldom covers the total loss to the landlord, and once a delinquent tenant is evicted, the odds of collecting anything is close to zero. I feel that the process that is currently in place is more than adequate, and for the reasons stated, I would urge a negative report. Thank you for your time and consideration.
Thank you, sir. Next, Aaron Bradley, followed by Bill Costelli.
Once again, Aaron Bradley representing AOBA for the record. So the panel has already covered so much of this bill. I will just add that for the jurisdictions AOBA represents, notifying residents of outstanding rent already occurs in the existing process. In Prince George's and Montgomery counties, there is a mandatory grace period before late fees can be assessed. So prior to the late fee being assessed, on the 10th day in Montgomery County and the 5th day in Prince George's County, so prior to that assessment of late fee, housing providers notify the resident that their rent is past due and their outstanding rent balance is also provided to them. So that notice is provided. Grayson also mentioned that there are additional notifications prior to the need to appear in court for a failure to pay rent action. And as you can imagine, we were concerned about the return receipt requirement, but it sounds like that may change. And so we would look forward to seeing that. I'm available for questions. Thank you.
Okay, and Bill Costelli is signed up as well in opposition. Bill, you out there? No, Bill. Okay, we will go to questions for the opponents. I think Delegate Stewart has the first hand up.
Thank you, Mr. Chairman. So, Ms. Bradley, it sounds like we may be closer to a compromise here than I sort of thought when I first heard about the bill. So could you just repeat exactly, what Montgomery County and Prince George's do now? It sounds like Montgomery County has like a statutory 10-day grace period. Prince George's has a statutory 5-day grace period. And then landlords generally notify the tenant before either the 10 or the 5. Is that right?
Sure. So that's the grace period before assessing late fees. Yes, there is a mandatory period in there. And then at that time, either on the day of the late fee can be assessed or prior, depending on, companies' business practice. Management companies provide the tenant, the resident, with the notification of their outstanding rent and the balance, but not through mail, like at the door.
And then in both of those jurisdictions, there's a 5-day sort of industry practice grace period before filing summons. Is that right? That's what Ms. Howard was saying, I guess.
Yes. Yes. I mean, that is the industry standard that there is. And of course, Kathy can speak to what happens outside the jurisdictions I represent, but yes, there is an industry standard.
Okay. And so I guess my question is, I mean, if we could figure out a way to make this notice thing appropriate. I get the point of like certified mail not being great, postal service not being reliable, having to understand when people actually receive it, and that being difficult for both the landlords and the judiciary to decipher. I get all that, but assuming that we could figure out a way, a sort of acceptable delivery mechanism, is there some sort of compromise that we can make because to me, it honestly seems pro-landlord to provide a little bit more of a grace period so landlords don't have to keep going to court over and over and over if people would be willing to pay. I mean, just to the chairman's point about turning the lights off, I actually, while he was making that point, like 30 seconds after the chairman made the point about the lights going off, I got an email notice from my child's daycare that I haven't paid the daycare that was due yesterday on the 15th. And they're not going to yank my kid out of daycare or take me to court.
I'll have staff notify Child Protective Services.
Exactly. You can just forward the YouTube link to them. But yeah, fortunately, I'm not going to have to go to court today or tomorrow this week. Fortunately, my child will continue being able to go to Zoom 2-year-old pre-K without being yanked out. He's not in person. But anyway, my point is, it seems to me that we get the delivery mechanism set up. Are you open to talking with the sponsor about, fixing that part of the bill, but providing sort of codifying a longer grace period so that landlords don't have to worry about going to court. And so for the tenants who genuinely are either waiting on, for example, rental assistance to come in or a paycheck to come in and aren't just not paying and need a reminder, that reminder can be a little bit more of a gentle one than a summons.
I think that we're always interested in talking to the sponsor and if we can find a solution, I think I think that's fine.
Okay, that's all I got. Thanks very much, Mr. Chairman.
Any other questions? Seeing none, thank you very much. Yeah, I think that's everybody who's testifying on that bill. So, okay, thank you very much. And definitely, I think Delegate Terraza, let us know what you think about what the court system said about your bill. I mean, I'm going to read that certainly. Okay, that ends the public hearing on that bill. Let's go to House Bill 825, Delegate Healy.
Thank you very much. I have two bills, they're one right after the other, 825 and 826. They're very similar. Would you like me to present them together or separately?
No, let's, nobody signed up in opposition to either of them. If you want to present, I mean, how different are they?
They're very similar. One of them deals with condominiums and homeowners associations, and the other one, because it's a different part of the law, deals with co-ops. But it's trying to get
do them together. Well, do them together. You present them together, and then it looks like, well, the witnesses are a little different. I changed my mind. Do 825. We'll have questions. We'll have witnesses and questions. Then we'll go to 826. I think that actually might be simpler. I could be wrong, of course.
Okay, of course. I'd be happy to do that.
Okay, and restart the clock, please. Go ahead.
Okay, Mr. Chairman, members of the committee, House Bill HB 825 is about cooperative housing corporations and dispute settlements and eviction procedures. Back in 2014, we passed legislation that provides for a dispute settlement procedure under the Maryland Cooperative Housing Act that's similar to the Condominium Act. However, the 2014 bill also included the collection of assessments in the dispute settlement process. Such assessments are not included in the Condominium Act, and we'd like to correct that and make them the same so that it would not be included in the Co-op Housing Act either. The additional requirement for administrative dispute settlements process sometimes unnecessarily delays and complicates the collection process for these nonprofit co-ops. There's also the other part of it is where it's really like the other bill. There's an additional layer of procedure that delays and complicates, as I said, the assessments, but also the dispute settlement procedure now requires, in both areas, requires that you have an automatic appeal rather than an appeal that's requested by the person who is being given having a problem with the co-op or with the condo association. If they want to just deal with it, they still have to go through this automatic appeals process, which is burdensome for the co-op association as well as for the others. So that's basically what the bills do. They're similar and different. So I started with the one that's most different with all the different co-op stuff. And I'd be happy to answer any questions, but I think the panel will be better.
Okay, thank you, Delegate. Do you want to start with Lisa Jones?
Please.
Okay.
Hi, good afternoon, Mr. Chair, members of the committee. I'm Lisa Harris Jones, and I'm here on behalf of the Community Association Institute. And House Bill 825 and 826, the sponsor was accurate. They're very similar. The difference being 825 deals with co-ops, while 826 deals with HOAs. And in both cases, these bills bring the law with with respect to co-ops and HOAs in line with the Condominium Act with respect to dispute settlement. Specific to House Bill 825, there was a law that passed in 2014 that kind of complicated the law with respect to assessments. And I should point out that both bills, 825 and 826, have been heard by this committee. They passed out of the House in 2018 and in 19. The Real Property Subcommittee spent a lot of time on tightening these bills up, so they're not new to this committee. But in each case, it gives the tenant or the homeowner a right of due process if there's concerns with a dispute. In light of a co-op, if someone is behind in assessments, this bill tightens up the law where in co-ops, because of the nature of the ownership of a co-op is more of a landlord-tenant, and the landlord-tenant law applies. It cleans it up so that assessments, someone behind in assessments, you would go into the Maryland landlord-tenant law as opposed to the complication that was made in 2014 when they brought in dispute settlement and applied it to how to deal with someone behind in their assessments. And they cleaned that up so that the co-op does not have
Lisa,
to,
if you could wrap up, please.
Yeah, it's complicated, but the bill is a bill that has been heard by this committee, has been vetted, cleaned up, and has passed out twice to the Senate.
Thank you. Delegate Healy, would you like Beth Citronini to go?
I think it doesn't make any difference.
Okay.
You know, at this point, I just wanted to make sure that Lisa had the chance to.
Sure.
be there.
Okay, then Beth Citronini, I'm sorry if I'm.
Citronini. No, you're fine.
Yes. Okay.
Thank you. My name is Beth Citronini. For the record, I am the accountant with Armistead Homes Corporation. They are a low-income, predominantly a low-income community in Baltimore City with about 1,600 homes. The way the bill was previously written, it created a lot of significant costs to fulfill the requirements of that bill. In an impoverished community, they ultimately had to bear the consequences of that. So we are fully supporting the changes, as Delegate Healy had said, and we feel like it's much needed. But if you have any questions, feel free to let me know. I'm here to answer questions.
Okay, thank you. And then John Soroka. Mr. Soroka, are you here for 825?
He's there. I think he's on mute.
Okay.
There we go. Can you hear me?
Okay. Yes.
Yes, I'm the senior accountant at Armstead Homes, and just to piggyback on what Beth said, this has caused, the current bill has caused a lot of significant issues in our co-op, just from postage, from delays in the processes. I think what is proposed by this action would significantly help the co-op in total and 99% of our leaseholders. Thank you.
Okay, thank you very much. Delegate, I think that's all the witnesses we have for 825. Why don't we take questions for that bill?
Okay.
Delegate Stewart?
Thank you, Mr. Chairman. Thank you, Delegate Healy, for bringing this. I'm just trying to wrap my head around it. I don't really remember this from 2019. I'm not on the subcommittee. I'm just trying to understand what this is. So I guess, Ms. Jones, so I guess right now what you're saying is that before a co-op, a cooperative housing building, can evict someone for failing to pay rent, for example, they have to go through a dispute resolution process. Is that right?
It's my understanding is quite the opposite on the eviction side. So on the eviction side, the co-op is more of a landlord-tenant relationship. The problem is in 2014, when a piece of legislation passed dealing with dispute settlement, it pulled co-ops and HOAs in by mistake, and it included, before you could even get to the traditional landlord-tenant law, it force co-ops to have to go through a process that you use for something that's like if someone can't work properly, where you would have a notice of a violation, a notice would have to be served, there would have to be a hearing. It complicates the whole process unnecessarily. So this bill cleans that part of the law up and takes the assessment portion out and puts it and keeps it where it belongs in the landlord tenant section, but also tightens up the process. There is a dispute with someone living in a co-op. They're provided proper due process. In the past, you had to have a mandatory hearing. In this case, the tenant has the option of asking for a hearing and getting notice of that hearing. Then there's a process within the law on what happens after the hearing. So it's a cleanup bill from something that happened in 2014, unfortunately, that mixed two laws together. That makes sense.
Okay, thank you very much.
Any other questions? Doesn't look that way. Okay, I guess that ends everybody's testified, so I guess that ends the public hearing on House Bill 825. Let's go to House Bill 826. Delegate Healy.
Thank you very much. House Bill 826 applies to condominiums and homeowners associations, and it's about, again, about dispute settlement, but this doesn't have anything to do with what we were talking about on assessments. This is more about really taking it, moving it from having an automatic appeal when there's a dispute to having an appeal when it's requested and having the opportunity to make that appeal. This is a much simpler bill than the other one, although it has some of the elements of the other bill we just talked about. And this deals only with condominiums and homeowners associations.
Okay, thank you very much. Next, Lisa Jones.
Again, thank you, Lisa Harris Jones here on behalf of CAI. Again, this is a bill we are asking for support of. It passed out of the House in 2018 and 19. It was worked on in the Real Property Subcommittee. It cleans up the HOA Act with respect to dispute settlement. It discusses the fact that you no longer would have to have a mandatory hearing, but a homeowner would have the right to ask for a hearing within a certain amount of time. They're provided notice. There's provisions on how that notice should be given to that homeowner and how long before after the homeowner requests the hearing, when that hearing has to be had, and what happens when the homeowner decides not to have the hearing. Again, it's a cleanup bill. We've worked on it for several years, and it just has had, unfortunate problem of hitting the Senate where it has not been, was not taken up for a vote. And I just asked for a favorable report.
Okay, next, Karen Strawn.
Thank you. My name is Karen Strawn. I am with the Maryland Office of the Attorney General in the Consumer Protection Division. And we support this bill mainly because it adds the dispute settlement procedures to the Homeowners Act. Why this is important is because without this, you have to rely upon their governing documents to provide dispute settlement procedures. Some governing documents provide them, some don't. They are varied in how they provide those rights, and they don't necessarily ensure that due process actually happens in some cases. We want to ensure before you take away the right of someone to vote, before you fine someone for a problem, that you are giving them the right to challenge that decision, to determine why the violation is being had, and to make sure that that violation is actually found before there is a infringement of rights or a fine assessed. And so for those reasons that it adds to the Homeowners Association Act and puts the dispute settlement procedure within the Homeowners Association Act, we ask for a favorable report on this bill.
Thank you very much. Gwendolyn Cousineau. Ms. Cousineau? Okay, she's not there. Questions? Okay, no questions. Well, the last bill is hopefully going to be House Bill 541, Montgomery County delegation. Monsieur Moon should be in the House, I hope. I have texted him.
Thank you, Mr. Chair. Apologies.
Not at all.
We had simultaneous hearings going on, so I had my Ferris Bueller moment today. In any case, House Bill 541 is very
Wait a minute, let
simple
me just
local
correct
bill.
something. It's not the last bill, second to last. Go ahead, I'm sorry.
Okay. 541 is a local bill from Montgomery County. It simply adds a notice to home sale contracts that warns home buyers that our school boundaries may change. This language was worked out with GCAR, our local realtors. The bill is supported by the county executive and county council, and it passed unanimously out of the delegation. So we ask for local courtesy and a speedy favorable vote, but I'm happy to answer any questions.
There is no one else, there's no one signed up in opposition and no one else signed up in support either, though. But any questions for Delegate Moon? Okay, seeing none, thank you very much. That wasn't so painful, David. Come on. All right. This is the last, I swear, this is the last of the afternoon. House Bill 877, Delegate Valentino Smith.
Thank you, Mr. Chairman, members of the committee. Quite a fright there when I thought you thought I would. Look, I'm here as the House Chair for the Joint Committee on Ending Homelessness, and I'm excited. You know, we did a lot of interim work. We write a report to the Speaker with recommendations. House Bill 877 work group on adaptive reuse of vacant commercial properties stems from a lot of the work we did this summer. Pre-pandemic, you know, we've had a housing inventory shortage. The pandemic has only created a crisis within a crisis for many that are housing insecure. And again, finally, the long-awaited Maryland Housing Needs Assessment 10-year strategic plan came out thanks to Delegate Brooke Learman. And that emphasized to us even before the pandemic that we had a shortage of affordable and available units with a deficit about 85,000 units for low-income households. Between 2020 and 2030, we're going to add nearly 100,000 new households that are going to earn less than half of the median income. And out of 167,000 severely cost-burdened renters in households, more than 120,000 will have extremely low income and be at risk of losing their housing. So the Joint Committee devoted a lot of time to the concept of adaptive reuse. We brought in the Fair Housing Action, DHCD, National Conference of State Legislators came in. We studied a really creative example where the Lord Baltimore Hotel was used to house homeless during the pandemic. We heard from a lot of the counties, and MACO came in, that the counties then were able to use vacant hotel space with CARES Act funding to immediately create shelter and housing for the homeless. So we clearly saw as policymakers that when you have available units and you have money, you can really quickly accommodate housing units that are needed. So the Joint Committee looked at all this and believed that it's really worth setting up a task force to look at and to address this problem. There's nothing more significant than the fact that now we have vacant buildings, we have vacant shopping centers, and maybe some vacant hotels, and post-pandemic, we may even have a greater influx of them. Across the country, NCSL came in and talked to us about in Ohio, where a former hospital was turned into 137 dwelling units after sitting vacant for 12 years. In New Jersey, a former opera house was converted to housing for homeless veterans. In Virginia, a lumberyard was converted into affordable homes, and the opportunities are endless. So putting together, I know the last thing people want to do is a task force and a work group, but we really could avail ourselves of putting together a diverse group of people. A lot of amendments have come in. I think the architects and other people I think are worthy of adding to this and set us up in a position to do the evaluation on what is needed to help spur the use of vacant commercial property for affordable housing. And I can think of nothing more exciting than for us to start to have recommendations to use this type of effort. The federal government does a program similar for vacant federal property. And imagine being able to see some of these properties come to life if we start to understand what the restrictions are, what incentives are needed, or what we can do to help energize this movement. So with that, on behalf of the Joint Committee on Ending Homelessness, we would ask that you help support this bill that we highly recommended to the Speaker as a needed effort to address our housing and security needs. Thank you, Mr. Chairman.
Thank you very much. Chris Parts is signed up in favor with amendments. Chris, are you with us?
Yes, I am.
Okay.
Thank you, Mr. Chair and members of the committee. I'm Chris Parts with AIA Maryland, representing nearly 2,000 architects across the state. And we're simply here to add the expertise that we believe architects should bring to this work group. We've talked with a sponsor, and we believe that that there are a few reasons why architects are important to be a part of this work group. First is that code requirements are different for commercial versus residential buildings, and architects are probably the best suited to understand the challenges and opportunities in converting commercial buildings to residential use. Some of these requirements might impact things like the numbers of exits required, distances between exits, not just doors, but stairs too, and required fire separation. So this is an expertise that architects can bring. Secondly, part of making housing affordable is also trying to reduce operating costs. And in addition, and architects, I think, are particularly well-versed in understanding and identifying structures that might most readily be adapted to reduce demand for energy and identify options for integrating possible renewable energy sources to reduce power demands and operating costs on buildings. And finally, essentially, architects are typically creative problem solvers that try to identify opportunities for reducing costs on solving issues like this. And we ask for your support of House Bill 877 and consider our proposed amendment. Thank you.
Thank you very much. We've got a question from Delegate Healy. Delegate Healy, go ahead.
Thank you very much, Mr. Chairman. My question is about does this also require like zoning changes? Because the way we have zoning done, we keep residents and businesses apart a lot of the time. Will local governments have to get involved in changing their zoning to make this kind of thing work?
Yes, I think I didn't get a chance to see the full sign up list. Mako sign up in support of the bill. So the idea is to come outside of session and take a really strong look of what is needed to be able to help go down this avenue. And obviously some of that is looking at local and state zoning laws and deciding, what incentives there should or shouldn't be. We do that now for affordable housing builders, but just to really take the deep dive into how this can be done.
Okay.
Avoid having all of this vacant property that's already built.
Actually, Delegate, it looks like MML signed up in favor, but not Mako.
Okay. Mako came to the Joint Committee on Ending Homelessness and gave us a big briefing, so we'll work on that.
Okay. Yeah.
Okay. The other piece of it is just I wanted to ask the architect or the delegate about does this envision like completely redoing an office building into residence, or can you do a mixture, like every other floor being residential or sections of the building being residential versus others? We have already some of that with ground floor sometimes having businesses and the upper floors having residential, but beyond that, is that what this is going about? Like if you have an old office building and you can mix and match?
Why don't I let the architect explain what's done, and then I'll give you a national example.
Certainly. And much of the work that we see that's happening with new construction now is actually mixed use properties where you might see a ground level commercial space and upper levels will be residential. One of the concerns between this is that you need a 2-hour horizontal fire separation between commercial and residential uses. So the needs just because in residential uses you have folks that are sleeping and want to provide added protection for folks to get out and timely exiting. So it's really taking a look at, you can certainly combine uses, whether it's office and residential or commercial and residential and other, other opportunities. But I think that it's just making sure that we understand what are the requirements for life safety to enable that to happen. And often when you do combine uses, those are really better, a greater benefit for the community.
Thank you very much. Appreciate it.
And Delegate Healy, in Florida, what sparked my interest was they started to use vacant shopping center space because of the way that was configured to do a combination of business and residential.
Thank you.
Are you good, Ann? Okay. Delegate Lehman.
Thank you, Mr. Chair, and thank you for bringing this bill, Delegate Valentino Smith. I think it's excellent. I just wanted to point out, actually, I think some local governments are, ahead of you on this. I know there was the other Derek Davis in politics, Prince George's County Councilman Derek Davis did a bill a few years ago that Delegate Harrison remembers, allowing for the conversion of commercial office buildings in these office parks that are now pretty much empty. That was starting to be the case even before the pandemic, but allowing the conversion of those to multifamily housing. So I think there is a template, and again, it is a zoning issue. So Delegate Healy is correct in asking that question. It'll be interesting to understand what, if any, concerns that MACO has, because it would have to be taken up on a county by county basis from a land use and zoning standpoint. So
that's why we thought a task force was better than a singular bill, to let everybody get in and decide what recommendations as a kind of protocol for the state to use.
Right, that's a smart approach. Thank you, Mr. Chairman.
Delegate Terraza.
I was trying to get the mute button. Thank you, Mr. Chairman. So has there been discussion and sort of how you would look at making sure that this wasn't just a conversion of commercial to residential, but actually looking at longstanding abandoned commercial?
Yeah, I mean, that's why the task force is written a bit broadly, and we're certainly open to changing it, was to make sure that we put a group of diverse people with different varying specialties together to help make recommendations on how it can be done, where it should be done, and what types of buildings work better or don't work, or why it's helpful to the state, sometimes to use what's already built, no matter how long it's been built. It's a better project. Sometimes it's better to knock it down and build just new. But the idea was to look at what the state would need to do to try to achieve more affordable housing and or transitional housing for those that are homeless and low income.
I've got a question for Mr. Parts. Maybe this is too vague a question for you to answer, but when you're engaged in attempting to convert to residential use a formerly commercial property or an industrial property, I mean, to the average lay person, it seems like it should be a very easy thing to do. But my late father was an architect, and he used to tell me all sorts of stuff, and I'll bet it's not an easy thing to do. Am I wrong about that?
It's I think that there are typically, as you're taking a look, for instance, at residential units, you might have certain depths of a unit that might be most convenient to work with. And some office properties may lend themselves well to that, some may not. I know, one project that we had worked on, we had a considerably deeper unit. So we had to think about putting, kitchen and bedrooms in the back that have an opportunity to borrow daylight, where you only have one wall that has windows and you're borrowing daylight through the unit instead of having a bedroom, for instance, on a perimeter wall that gets daylight. So that's, one example of trying to think about that. Another example is, two buildings side by side, we were able to think of a way that put an elevator and a stair tower between the two buildings that essentially saved the owner the cost of having to have two stair towers and two elevators. So thinking about different ways of, connecting things and working with dimensions that work for, the way the property would be used, I think is just takes different opportunities to think about possible solutions there.
Okay, interesting. Any further questions for any of the proponents here? Nobody's signed up in opposition. Okay, well, that concludes the public hearing on House Bill 877. Thanks, everybody. Announcements. Subcommittee chairs, announcements.
Mr. Chairman.
Yeah, Jim, was that Jim? Yeah.
Okay, everybody, it's 4:10 now. Let's have Ag and Open Space Subcommittee meet at 4:25.
Okay.
Come through 4:25.
Vice Chairman.
Thank you, Mr. Chairman. The Environment Subcommittee will be meeting tomorrow morning at 11 a.m.
Okay. Marvin.
Thank you, Mr. Chair. The Housing and Real Property Subcommittee will also be meeting tomorrow morning at 11 a.m.
Okay. Who else? Sub-chair.
Chair.
Yeah, Delegate Learman.
I just wanted to report that land use met today before our hearing, and we are going to be doing that moving forward. So just everybody, we sent a calendar invite, but from now on we'll be meeting before the committee meets on Tuesdays. Thanks.
Okay. Anyone else? Anyone on the committee at all have an announcement for the good of the whole? If not, we're adjourned.